May I please recommendation for item number 51, madam. 51 item number. Can you maybe pass over for that day, madam? I have given mention.
It will be in the list.
Yes, sir.
Let us see. Not at this moment. They're all 2015 matter.
Yes, sir.
Let us see.
My pleasure. I'm paying for listing of matter on Monday. Today morning we have filed the matter.
When did you file?
Good morning, just before 10 minutes.
If it is not defective, because
Yes,
we
sir.
found many such mentions
Lordship.
been made, they are sending it, the petitions are defective, subject to defective,
Lordship.
correction of the defective.
Yes. On Monday, Lordship.
Subject to condition that.
Lordship. That is.
I beg to mention item number 3 to 13, Lordship.
Huh?
Item number 3 to 13, Lordship.
Huh?
This with due consent on the other side, this matter will be taken up with some other dish, Lordship. My senior is not well.
Who is your senior?
Devar Sharma, D. Sharma.
Let us see.
Keep yourselves.
You are appealing on whose behalf?
Respondent applicant in the implement petition, Lordship. We have not been made party respondent by the petitioner. Lordship.
What's your good name?
And Shyam.
You are appearing on whose behalf?
Respondent and applicant in the implement petition, Lordship. We have not been made party respondent by the petitioner. Lordship.
So you are appearing for Moinul Haq Chaudhary and Dhruvoজ্যোতি Saikia,
Yes, Lordship.
the applicants.
No, Lordship, we have not been made party respondent in the petition.
But now you are appearing for the applicants or for whom?
For respondent, Lordship.
Which respondent? You are saying that your names are not there as respondents.
Lordship.
Who has filed the application for impleadment? You have filed or somebody else has filed?
We have.
You have filed. Okay. You want your names to be impleaded.
Yes, Lordship.
Why?
Lordship, the original petition, we have challenged the promotional notification, Lordship.
You have challenged the notification or the petitioners have challenged the notification?
We have, Lordship.
In the writ petition.
Yes, Lordship.
Who filed the writ petition?
We, Lordship, we have filed.
You have filed the writ
Yes,
petition.
Lordship.
You are appearing for Anjan Kumar Das.
No, Lordship, that is, what is it?
You open the file and let us know you are appearing for whom. When did you join the bar? Madam,
Lordship, 2016.
2016.
Lordship.
See, this is an opportunity you are getting, right? Otherwise, all the seniors should have taken over. So see the application and tell us you are appearing for whom? The writ petitioners or you are appearing for the respondents?
Respondent, sir.
Which respondent?
Respondent. I
Mr. Bora, guide her. Just guide her.
After some time.
Okay. Just tell us you are appearing for whom. We want to know from that, from you. You are appearing for somebody.
Also applicant, sir. Applicant.
Applicant.
Yes, Lord.
You want your names to be there in the writ petition.
Yes, Lord.
You have not been made a party. In the writ petition,
Yes, Lord. Sir.
can you tell us for whom you have, who is your client? You are appearing for whom?
Party has not been made, so we have
Lord, sir, we have not been a party respondent by.
So you have not been made a party respondents in the writ petition.
Yes, Lord. Sir.
You have filed
We have
application
filed,
for impleadment,
petition, Lord, sir.
right?
Yes, Lord. Sir.
Now, why you want to implead? You are aggrieved by something. Why do you want to be impleaded in the writ petition?
Because party has not been made, Lord. Sir.
What is your grievance? How will you be affected if you are not been made a party? How you are affected? Yes.
the present applicants who are the petitioner has not been belongs to God. Since the official party has established before, should not referring
Lordship, page number 7, Lordship, the applicant humbly submits that now the present writ petitioner and opposite party, number 1, has approached before this honorable court but by filing this present writ petition being WPC number so and so, but in this present writ petition in the applicants who are the writ petitioners in the WPC has not made as party respondent by the writ petitioner and opposite party number 1. Since the opposite party number 1 has approached before this honorable court praying for an order or direction commanding the respondent to release the area of salary corresponding to the post of statutory officer in agriculture along with other relief in the light of the promotion notification dated 19/9/2020, whereas the promotion notification dated 19/9/2020 has been challenged by the applicant in WPC number so and so, in which this honorable court by order dated 21/10/2020 observed that any promotion made in favor of respondents shall be subject to the result of the writ petition. Therefore, the applicants prays before your honorable court to allow them to be implemented as party respondent in WPC number.
So the applicants are neither a proper party nor a necessary party in the present proceedings, Lordship.
Why do you want your names to be incorporated in the writ petition? Why?
Lordship, I am not aware about this matter, Lordship, kindly.
Read, you read, and tell us. Read para 5 at page 7 of your application. Read para 5.
That the applicant humbly submits that now the present writ petitioner and opposite party, number 1, has approached before this honorable court by filing this present writ petition in WPC number. And so, but in this present writ petition, the applicants who are the writ petitioners in the WPC number has not been made as party respondent by the writ petitioner and opposite party number 1. Since the opposite party number 1 has approached before this honorable court praying for an order or direction commanding the respondent to release the arrear of salary corresponding to the post of statistical officer, agriculture, along with other release in the light of the promotion notification dated 19/9/2020, whereas the promotion notification dated 19/9/2020 has been challenged by these applicants in WBC number, and so in which this is honorable court by order dated 21/10/2020 observed that any promotion made in favor of the respondent shall be subject to the result of the writ petition. Therefore, the applicants prays before your honorable court to allow them to be included as party respondent in WPC number.
Now, what you have understood from this? This is your submission. So tell us what is happening.
Let's say these are some.
So you have filed some writ petition challenging that notification of seniority of the writ petitioners in which we have not been made a party, and that writ petition is pending, right? Where there is a stay subject to the outcome of that writ petition. So without making you a party in that writ petition, you want to be implemented. That's the reason. So you should say that. Are you scared to say this? Now just read again of yourself and express it to the court. Read para 5 for yourself and read it for yourself and express it. The facts you know there only. Read paragraph 5 of your own and tell us. You read it first. From reading the same, you will understand something. You read it and you'll understand something from there. You read it slowly for yourself and tell us, you express it before the court. Then you will make a submission. See, don't miss these chances. You'll never get these chances second time. You'll remain as a lawyer only for seeking time. What's your good name?
And
MS Shyam, counsel appearing for the applicants. and Mr. H. Besbarua, counsel for the opposite party number 1/lead petitioner. Who is appearing for agriculture? What's your good name? And I'm Mr. Zebora, standing counsel, Agriculture Department for the respondent opposite party numbers 2, 5, as well as Mr. P. Nayak, standing counsel finance for the opposite party number 3. Who is for AG? Okay, Mr. B. Chakraborty. Okay. Not 3. So we probably you are appearing for 6 AG. On item number 3 and 4, you are appearing. Any other, sorry,
My lord, in item number 5, 8, and 9, I am appearing.
Let me put it like this. Yes, tell us, Mr. Hassan, you are appearing for whom?
My lord, for accountant general.
No. Which
In
rest?
item 5, 8, and 9.
Yes.
Proceeding item number 6, 10, and 12.
What's your good name?
KK Mehta.
Full name?
Kunal Krishnan Mehta.
K. It starts with K. K. Medhi. 6.
6, 10, and 12. Item only 13.
My lord, item number 13, Mr. R. Dhor, his name may be recorded, madam. Item 13.
There is another one. You are appearing for whom?
My lord, I mean,
Mr. Medhi. You are appearing for AG and AE Assam.
On behalf of SK Mehta. On behalf of Mr. SK Mehta.
Here, Respondent number 6, opposite party number 6, currently 3 year code, the Chakraborty. Item number 5, 8, 9. Who is appearing for 7? Mr. Hassan, who is appearing for 7?
Gautam Patwari. Gautam Patwari.
7 and 11.
7 and 11.
Hey, Hassan, distributing all. Yeah, Hassan for 5, item number 5, 8, 9, 9. KK Mehta on behalf of Mr. S. Committee for item number 6, 10, and 12. RK Talukdar for 7, 11. Art Hall 13. Complete vote. Stating that they as repetitioners preferred WPC number 4373/2020 wherein the notification dated 19/09/2020 by the respondent authorities in the agriculture department promoting the opposite party number 1 along with 12 others to the post of statistical officer in the agriculture is under challenge, wherein the court on 21/10/2020 observed that any promotion made in favor of the respondents therein shall be subject to the result of the said writ petition. Ms. Shyam, appearing for the applicants, stated that the petitioner of the connected WPC number 4088, Anjan Kumar Das, is the party respondent number 9 in their said WPC number 4373/2020. But without making the applicants a party respondents in the connected WPC number 4088/2023, the opposite party preferred the same, praying for certain benefits that relates to their promotion on the basis of the said notification dated 19/09/2020, that is under challenge in WPC number 4373/2022, sorry, 2020, preferred by the present applicants, which is presently pending for consideration. Pending for adjudication. As such, the applicants, as such, Ms. Shyam, appearing for the applicants, submitted that the present applicants are a necessary party in the connected WPC number 4088, filed by the opposite party number 1, Anjan Kumar Das. By order dated 9/09/08/2023, court directed the present opposite parties to file their respective applications, if any, on or before 21/08/2023, with regard to the implement of the present applicants, the connected WPC number 4088/2023, fixing the matter today. No such objection has been filed by the opposite parties with regard to the implement of the applicants, the connected WPC number 4088, as directed by the court on 09/08/2023. It is seen that the present applicants preferred the connected WPC number 4373/2020, wherein the present opposite party is the opposite respondent number 9. To that extent, the applicants have annexed a copy of the order dated 21/10/2020, passed in said WPC number 4373/2020, referred by them. Considering interest of the matter, the court is of the view that the present applicants are a necessary party for proper adjudication of the present WPC number 4088/2023, which has the connection with WPC number 4373/2020. Since the petitioner was promoted on the basis of the notification dated 19/09/2020, issued by the respondents in the agricultural department to the post of statistical officer, the agricultural department is under challenge in the state WPC number 40 such number ID 4043732020. Accordingly, these interlocutory applications stands allowed. The present applicants be imputed as party respondent numbers 6 and 7 in the connected WPC number 4088/2023. Next letter. In view of the order passed to the connected IAC number 2224/2023. The applicants Moyul Haq Chaudhary and Dhruva Soikia be included as party respondent numbers 6 and 7 in the present writ petition. The concerned section of the registry shall accordingly correct the cost title. As MS and Shyam has entered appearance on behalf of the newly appointed respondent numbers 5 and 6. The petitioner shall has entered newly imputed respondent numbers 5 and 6. Issue notice to the newly imputed respondent numbers 5 and 6, returnable by 6 weeks. As Ms. Shyam and Sam has entered appearance, no formal notices need to be issued to the newly imputed respondent numbers 5 and 6. Petitioner shall serve requisite extra copies to Ms. Shyam of this petition to Ms. Shyam by tomorrow of the necessary acknowledgement. Registry shall reflect the name of Mr. D. Sharma and Ms. N. Shyam for the newly implemented respondent numbers 5 and 6 in the cause list. List accordingly.
Though the process commission, I had a submission. The interlocutory applications which I had filed for paying for my salary on the promoted post were disposed of by the honorable court, and it was a death
We have
petition.
seen subject to the outcome of the
My lord, it has been specifically held by the honorable court that this is a totally separate cause of action.
we have seen that.
It is not there.
that is-
It is not there in the interlocutory application, my lord. It is there in my writ petition. If lordship will kindly have the point of law, allow me to argue the point of law whether they are necessary parties or not.
We'll
I would
see
like
that.
to show, my lord, that
Please come to page number 17.
of the interlocutory application, my lord. But lordship will kindly have the final orders passed in the writ petition.
Listen,
Lordship will kindly have my writ petition for a moment. That's an order of the court, my lord. I'm trying to
you
be
have
upon.
filed Anjan Kumar Das, just a minute.
Lordship will have the writ petition for a moment. WPC number 4088 of 2023, page 36.
Just a minute.
Page 35, lordship. If still lordship finds that they are necessary party, I will have nothing to say.
Your interlocutory application.
My lord?
Your interlocutory application.
No, my lord. The writ petition 4088 of 2023, the writ petition at page 35. Interlocutory application is by them, and I'll show why this interlocutory application. I'll show that also. I'll bring that on record. Lordship will have the page 35.
Just a minute.
Question of a necessary party and proper party, my lord, would only arise if they have something, if the writ petition, my writ petition cannot be decided without hearing them. Are they required to be heard is the issue.
Mr. Taragot, more direction.
Now, Worship allows me to submit whether they are.
Mr. R.
necessary
Mujumdar.
parties or not.
Learned counsel appearing for the opposite party number 1. By placing the order dated 10/05/2023. Passed in IA 1344/2021. Next. As next of 5. WPC number 4088/2023. Submitted that the court, while considering the said IAC 1344/2021, observed that if the applicants are aggrieved in any manner due to non-payment of regular pay scale / pension, due to misconstruction of the order dated 21/10/2020, passed in WPC number 4373/2020, preferred by the present applicants, then the same would give rise to a separate cause of action for which they may approach the court by preparing appropriate petition, and hence pursuant to the said order of 10/05/2023, noted above, the present petitioner has preferred the connected WPC number 4088/2022.
Further submission, my lord.
However, it is
My lord, there is a
seen,
further submission, my lord.
however, it is seen, yes, what else?
My lord, a necessary party and a proper party in a writ petition would be
The
unnecessary party would be
petitioner-
one without hearing whom.
Petitioner submitted.
The cause of
That-
action is only my payment on the post on which I have served, which I am supporting by a judgment of this honorable court, my lord. Even temporary ad hoc mistaken appointments would be my right for salary.
Tried to establish before the court about the proper vis-a-vis necessary party in a proceeding, stating that his right accrues to the post of statistical officer on the basis of the promotion order dated 1909 such and such Friday, as well as holding that post initially on ad hoc basis and thereafter the said order. It is to be noted herein that the opposite party number 1 was not the applicant in said IAC 1344/2021. As such, the submission made by the for on behalf of the opposite party number 1 stands rejected.
My lord, the other IAs would be where they were the applicants.
I will pass the necessary order.
Whether the cause of action I pursue, or whether they can have a say in that, whether they're required to be heard or not, my lord. Why I'm submitting is this because, my lord, Lordship will just give me one more minute, my lord.
Yes.
The person, Moinul, not Moinul, actually, the other person is the person who is handling the law department, the law part in the department. And he has not made a single allegation in the earlier repetition against us.
That's good for you.
It is
But
not,
it's
my lord.
understood.
He's trying to just create a hurdle, not allowing me to draw my salary.
We'll pass the order necessary. Why are you waiting for that?
I'm-
We'll hear you at the right time.
People have retired, my lord, without getting their pension on their
We'll
posts.
pass the necessary order. Don't worry.
I'm sorry, Your Lordship, I could not reach on time.
Doesn't matter.
All, Your Lordship, as per the instruction of my client,
Administering Shekel and counsel for the petitioner. None appeared for the Respondents. Though names have been reflected in the cause list. On instruction of the petitioner, Ms. Srimati Sopanti Bora, BURH, Assistant Professor in Sociology and former Principal in charge of Nauboisha College, Gulahat, North Lakhimpur. Mr. Saika is not pressing this petition. Accordingly, this petition stands dismissed. Not raised. Any observation / interim order passed earlier accordingly stands vacant.
Yes, Your Lordship, my finger is not well. He's in a doctor's chamber. Might not be in a position to come back. Kindly list the matter after 2 weeks, Lordship.
Decca. There is submit about that counsel for the petition of Mr. Adhar is indisposed. There's this matter after 2 weeks on a date to be fixed by the registrar.
I'm appearing for respondent number 1235 for BTC and 4 for SSA for P9.
Look it over.
Obliged, Lordship.
Deeply obliged. 2 weeks or 3 weeks. You just confirm.
मेरी फीस Lordship. Lordship, whether the matter be taken up after some time, Lordship.
Why?
Lordship, my colleague, associate Lordship, Arboros, Lordship, she appears in this matter, Lordship. Lordship, she is here, Lordship. She was in another court.
Yes, ma'am.
Lordship, we have the recording.
Rua. ভিতৰৰ পৰা আনি পেলাই ইয়াত থৈছিল ন? Have you annexed the seniority list of the school?
My lord,
Have you annexed the seniority list?
seniority list, no, my lord. But it is not available with the petitioner, my lord. But as per my lord instructions, telephonic instruction, my lord, the petitioner, like after him, my lord, there are two more science teachers in this school, my lord, Sansari Adarsh school. But we don't have a, my lord, a copy of the seniority list, my lord. If required, my lord, we can produce it.
Yes, madam, just tell us what is the procedure for rationalization?
No, but there is the new amendment, there is a change of the meaning of PTR, your lordship.
Now, which are the teachers you will remove from the parent school? Which are the teachers? The senior most teachers of the school should be removed, or the teachers from below in the seniority list?
From the seniority list, my lord.
See, basically you have a rule
Yes, your lordship.
where seniority is counted for the post of promotion to the post of higher,
Hi.
highest principal,
Yes, your lordship.
principal, right? So it is school-wise seniority. Or in 2023, it has been changed.
Here, the meaning of PTR has been changed, my lord.
Minimum PTR has been changed.
Yes, your
What
lordship.
is that PTR?
Amendments of section 2, your lordship.
Tell
High
us.
PTR means a school where numbers of students or more than the teacher as per requirement of PTR norms, your lordship.
Yes.
And here it says that, your lordship, high PTR means a school where numbers of students are more than requirement as per PTR norms. Now that has been changed, your lordship.
When it was changed?
July 24, your lordship, 2023. I have given it on day after yesterday, your lordship.
Take your seats.
marks.
See, there is a specific provision, what we have seen here. The office memorandum of 5th of May, 2023. The education department have roll out the process of rationalization of teachers. How do you rationalize the school teachers following the PTR? So the process following the RT Act, and secondly, the number of enrollments. They have 2 classes high school, 5 classes high school, 10 classes high school. Then again, starting from course in 11 classes high school. Then 2 classes higher secondary school, single stream, 4 classes higher secondary skill, double stream. Then again, they have the triple stream. Stream in the sense the language. So they have followed all the procedure. Process we found quite good comparing to the on the basis, because it is on the favor of the students. But there is a rider. The rider is in the office memorandum, it has been spelled out very clearly that while first rider is teachers who have only 3 years to retire. are preferably not to be considered for rationalization. So those who are returning within 3 years, they'll be initially they'll be away, preferably they would say it will be away from rationalization. First, we will not able to consider them. Only when it is more you need, then only it will come. The next important clause is while rationalizing in a particular teacher category subject wise, the most junior teacher in terms of tenure in service shall be transferred first. Right? Now, from the records that has been placed before the court, what we have found, altogether, 7 teachers has been taken out from the Sangsari Adarsh Higher Secondary School. Out of these 7 teachers, 4 are arts teachers and 3 are science teachers. The record here placed before us also reveals the PTR of the same school in a different way. Say, for example, there is a school, Sualkusi Higher Secondary School. One arts teacher has been transferred from Sangsari Adarsh Higher Secondary School to this Sualkusi Higher Secondary School, where the PTR has been shown as 327 versus 18. That means 18 teachers are there, whereas the students are 327. Another teacher from Sangsari Adarsh Higher Secondary School has been transferred to this Sualkusi Higher Secondary School, where now the PTR has changed 275 into 19. That means initially it was 18 teachers, 327 students, same Sualkusi Higher Secondary School. Now for another teacher of Sangsari Adarsh Higher Secondary School, it has shown 19 teachers and 275. Big change. Now this list, while preparing, we do not know, because those 2 particular clauses, the 3 years duration, those who have service, then whether that seniority has been considered or not, that is not before us. So matter relates to Sangsari Adarsh Higher Secondary. What I will suggest, direct the inspector of schools to place the seniority list of the teachers of Sangsari Higher Secondary School as on 5th of May, because that office memorandum came on 5th of May. As on 5th of May, what is this seniority list? Whether this office memorandum has been followed, because the note reflects 2 things. It has not considered the new amendment provisions, which came later in July. But it considered the 2020 Act, the 2020 rules, and this office memorandum of 5th of May. So you have to give us the seniority list of teachers of 5th of May. We are fixing it on Monday or Tuesday. Right? Looking at all this, we feel that there is a requirement of rationalization, because there is a school where there are 842 students and only 15 teachers.
Yes, sir.
So these are lots of discrepancies are there. That's why you need to have rationalization, and it provides, Act provides, we will not disturb on that. But you have to tell us the seniority has been followed or not, along with date of birth, date of joining in the concerned school.
Yes, sir.
We pass the order.
Lordship.
Today is Thursday. You give it to us by Tuesday.
Yes, sir.
We'll consider it again on Tuesday. And if we feel that this proposition has been followed,
Lordship, I would like to bring one Lordship's notice in one thing, my lord. The new Act of 2022, my lord, it is not an repeal act, my lord. It amends certain sections, my lord. And my lord, high PTA and low PTA has been defined, my lord. My lord, the high PTA means a school where number of students are more than the number of teachers as per requirement of the PTA norms. But in the present case, my lord, Sangsari, it has got 540 students and 22 teachers, my lord.
as on that day when it was considered, it had 467 and 39 teachers.
And
Because
30?
it was in May,
39 teachers.
39. My lord, as per the
See,
Yes, my
basically true. You were right that even then you will see the PTR is high.
Yes,
Students
my
are more, teachers are less.
yes, my lord.
But here there is a list you have said, against 842 students, there are 15 teachers. Against 125 students, only 6 teachers. There are large number of likes. There's another school, Praveen Kumar Chaudhary High School. 794 students, only 14 teachers. So there is a requirement of rationalization to
Yes,
certain
ma'am.
extent. And in the office memorandum, they have followed a procedure requiring the minimum number of teachers. If because they could not fill up all the posts, probably what they have done. For example, there is a single stream, that means let us assume it's an Assamese medium school. And it has class 1 to class 12. So altogether 12 classes are there. Students enrollments 300 to 480, like this school. There, either the head, because if it is a high school, it will be headmaster. If it's a higher secondary, it will be a principal. Then assistant teacher, they have made it 0. But what they have done, graduate teacher arts, there has to be minimum of 2, because they have to rationalize in all schools equally. So what they have to, for the arts graduate teachers, there will be 2, science graduate teachers 2. If it is a higher secondary school, then there will be subject teachers, again 2, subject wise 9. And made a bounden duty that these subject teachers of class 11 and 12, they will be considered as assistant teacher for this rationalization, but the assistant teachers will not be considered as a postgraduate teachers for rationalization for the purpose of any higher secondary school. So they have followed this procedure for all, considering the number of students, the enrollment of students in that particular. So probably we are not going to that aspect.
Yes, ma'am.
Right, they have made a considering all aspects, because the students should at least have a teacher, either of science or arts. So they have followed accordingly. But want to see only this, whether the seniority position has been considered.
Yes, ma'am.
Pursuant to the order of the court dated Hard MS Sardova, counsel appearing for the petitioner and MS H10 P. Standing counsel, Department of School Education, for the responding numbers 1, 2, 3. Pursuant to the order dated 22/08/2023, Ms. Tangram have produced the relevant records in original regarding the rationalization of teachers in the district of Kamrup, wherein the inspector of schools, Kamrup Amingao, passed the impugn order dated 11/08/2023, transferring the petition from Sangsari Adarsa High Secondary School to Bongsar High School within the jurisdiction of the inspector of schools, Kamrup District Circle, Amingao, towards rationalization, so as to follow the pupil teacher ratio to the extent possible. From the records of the case, it is seen that following the provisions of the Assam Elementary and Secondary School Teacher within bracket Regulation of Posting and Transfer bracket close Act 2020, 1 to 3 to Assam Elementary and Secondary School Teacher within bracket Regulation of Posting and Transfer bracket close Rules 2022, and the government office memorandum and the office memorandum of the state government in the Department of School Education and the number 216176 dated 05/05/2023 issued by the Secretary of the Government of Assam in the Department of School Education relating to rationalization of teachers and post of teachers. A meeting was held on 18/05/2023. And accordingly, a list was prepared on 14/7/2023. And the district level, members of the district level committee, Kamrup Amingao, including the chairman, including its chairman and member secretary, on 14/07/2023 itself approved under a detailed list of rationalization of regular teachers of secondary education under Kamrup district. That includes transfer of 67 teachers serving under Inspector of Schools, Kamrup Amingao, for their transfer on the ground of rationalization to other such secondary schools of the district of Kamrup, where there is a requirement of teachers, assistant teacher arts and assistant teacher science. The said list prepared by the district level committee, Kamrup Amingao, was forwarded to the Director of Secondary Education, Assam, and it was approved by the Director of Secondary Education, Assam, as well as the state level committee. Thereafter, the transfer orders of those 67 teachers serving under the Inspector of Schools, Kamrup Amingao, were issued, including that of the impugned transfer order dated such and such of the petitioner. The members of the state level committee and the district level committee, being the competent authority for recommending transfer of teachers as per PTR norms, have been defined in the said 2020 Act. Page 67, sorry. Including assistant teacher arts division, assistant teacher science lekha. Arabic teacher, Hindi teacher, Persian teacher, and tutors. Both male and female. The office memorandum dated 05/05/2023 noted above. Contains the schedule of the Right to Education Act 2009 as well as the table 1, a module of minimum and maximum enrollment in a secondary school and teacher placement. Following one teacher per classroom, minimum of one teacher against maximum 40 students, one teacher for one subject, minimum enrollment in one subject as 10 per class, so 1 to 3 per class. Which PTR and PTR with minimum enrollment and minimum teacher as 25:1. Okay, minimum teacher 21:1, 40:1. PTR with minimum enrollment and minimum teacher 25:1. PTR with minimum enrollment, maximum teacher is 21:1. PTR with maximum enrollment and minimum teacher 40:1. And PTR with maximum enrollment and maximum teacher is 33:1. Sorry, available. As per the said office memorandum dated 05/05/2023, that's clear. But in the said office memorandum such and such stipulates at clause Roman 19 that stipulate while rationalizing, in a particular teacher category subject wise, the most junior teacher in terms of tenure in service shall be transferred first. And at clause 2022, clause 4 of the said office memorandum relates to rationalization of teachers and posts. Clause 19, subclause 19, and subclause 22 of said clause 4 of the office memorandum relates to provides that teachers who have only 3 years to retirement are preferably not to be considered for rationalization. From the records placed before the court, it is seen that altogether during the time of consideration of rationalization in the month of May 2023, the teacher-student ratio at Sangsari Adarsh High Secondary School was 467 enrollments with 39 teachers in position. After the decision of rationalization by the district level committee, altogether 7 teachers from Said Sangsari Adarsh High Secondary School was considered for rationalization. That includes 4 assistant teacher of arts and 3 assistant teacher of science, including the petitioner. As such, the inspector of schools, Kamrup Amingao, on the next date fixed, shall place the seniority list of teachers of Sangsari Adarsh High School as on 05/05/2023, i.e. the date of issuance of the said office memorandum, specifying their category, whether postgraduate teacher with the subject, arts teacher, science or arts, comma, date of joining in service, date of joining Sangsari Adarsh High School, and date of their respective date of birth, as well as date of retirement in service, from service. List on 29/08/2023 till then the interim order passed earlier on such and such. Ma'am,
Deeply obliged.
you are keeping the records. You can take that on the next date. For writing. Take this order around 3 o'clock from us. We'll serve you a copy.
Lordship, in this case, Lordship, readings are completed. May I pay for some accommodation come up after 10 days, Lordship?
Lordship, may kindly peruse the last order dated 25/7, Lordship. I place reliance on judgment, Lordship.
मुझे तो सुनना ही नहीं क्यों मुझे कोई सुनना ना कंटेनर लगता है
Not executing.
Yes, Mr. Roy.
Lordship, I have not gone through this judgment, Lordship. Let it be after 10 days, Lordship. I'm not
See, matter relates to pension.
pension, Lordship. I am
Yeah, I
understanding.
can understand. And whatever is entitled should be paid to him.
Lordship,
Law is settled,
Lordship.
right?
Lordship, as per our affidavit, Lordship, it
True.
is Lordship.
Same thing in the Apex Code also it was done.
Lordship.
Normally, I'll tell you, the officers of the departments, what they will to save their skin, they will not take any responsibility. No one will be that bold enough
Lordship.
to say that he is entitled in terms of judgment of the Apex Court or judgment of the passed by some other court, right? Otherwise, they will not say so. They will just follow the rules or they will pass. They will not even consider and they will push the persons to go to the court to claim their benefit.
Lordship.
So you see, you have seen, in spite of so many judgments of past with regard to disciplinary proceeding or suspension
That's it.
or other excess payment paid, nobody is considering, right?
Lordship.
They have to come to the court, they have to obtain an order and they have to do it. That's what is happening.
Only thing is
Here
the
also there is a judgment of the honorable court
Lordship.
placed by madam. Go through it and tell us, see,
Lordship.
these are the matters we do not want to do.
Lordship.
And also inform your authority that this is the law laid down by the Apex Court.
Lordship.
We cannot deviate from that.
Lordship, I will.
We are having it on seventh. Any difficulty?
Lordship, let it be on 11th, Lordship. 7, 8. I
So
will be-
11, let's see, I have some other matter.
12.
We'll have it on 12th.
Lordship.
On the prayer of Mr. Rastoy, Lanet CDC. Place this matter on 12th,
Lordship.
enabling him to go to the judgment of the Honorable Apex Court in the case of Ramveer Singh versus Union of India, reported in 2013, 7 SSC 316. Him as well as the respondent authorities.
God bless.
No representation on behalf of the petitioner. Though name of 3 councils have been reflected in the council. The court by order dated 27/07/2023 directed the respondents in the North Kachar Hill Autonomous Council to file their affidavit on or before 10/08/2023. Serving a copy of the same on the council for the petitioner and thereafter directing the petitioner to file her reply, if any, on or before 19/08/2023, fixing the matter today. Office note reflects, office note dated 22/08/2023 reflects that no affidavit has been received or been filed and received from concerned file or received from the concerned section from the respondent NCHSC, which was directed to be filed in 10/08/2020. Considering the above, you are appearing.
Also appear for the petitioner.
20,000 lecture for the petition. No representation, sir. This matter shall proceed without any such affidavit of the respondent MCHC.
Lordship, status quo will be followed.
The order of status quo was earlier on 19/06/2023 shall remain in force until further order.
I'm obliged, Lordship.
The standing counsel D. Upamana supposed to appear in this matter. He informed me that he's suffering from conjunctivitis, my lord. So I need some accommodation, my lord. At least 5 days, my lord. Files are also with him, my lord.
Your Lordship, what he told me in the morning that he has not received the records also. Your Lordship was directed. So I don't mind. He has some personal problem, Your Lordship. The only issue is that they
He
should.
can tell you the truth, but
As
not
I
before the
informed
court.
my lord.
Okay, this is for otherwise. Anyway, Mr. Sinha, we'll have it. This is on the ground because his
Yes,
health
Your
condition
Lordship.
will consider. Ma'am, give us a date. Give us a date.
After 5 days, my
We
lord.
will not say anything. You give us a date. Accordingly, we will fix.
First,
But next time, Mr. Ubomendo should not come before the court saying that he hasn't received the records. That is clear. Right?
maybe my lord.
No, we do not. We are not running over. Thing is, tell him that he doesn't come before the court without the records. So the next date. So accordingly, we fix the date.
Let it be on 34th.
11th or 12th September, my lord.
No.
Let us see, because let us see the board on that day.
I don't think so much time will be required, Your Lordship.
Let it be on 12th of September.
My lord,
But on that day, Mr. Ubomendo, we need the records.
my lord.
It is submitted that Mr. D. Ubomendo, Standing Counsel, Higher Education, who is representing higher education in these cases, in this court, and suffering from eye problems. As agreed by the parties, list on 12th of September, along with the relevant records as directed earlier on 17/08/2023.
Obliged.
Mr. Talukdar, you are appearing for whom?
That's number 8, my lord.
You are for AG.
Respondent number 10.
No affidavit has been filed, my lord, and subsequently, my lord, similar required person approached before the honorable court. Rate appeal 133.
Sir, ask your colleague to have one, either Mr. B. Gogoi or Mr. P. Nayak, finance. Why you have not got finance separately here? Huh? You're an experienced counsel, you know whom to be made.
Maybe party treasury officer. My lord.
Treasury officer won't do, treasury officer will pay you, you should know, Mr. If you want to help your client. Get anyone, name is there anyway, you will appear. We'll pass the order in presence of Standing Council Finance.
There's a small update that I wanted to bring to your kind notice. There's a judgment of the Honorable Division Bench that has been passed, writ appeal 133 of 23, wherein the case of the Gaon Panchayat secretaries have been dealt with. The initial date of appointment was 1993. At that period of time, they were appointed against non-sanctioned posts. I have a copy of the judgment. My
I will also have it.
Yeah.
Okay, give it to us. Yes. Yes.
So, my lord, as per the order passed in the writ
Who
appeal,
preferred that appeal?
my lord, the state had preferred that.
State preferred the appeal. What was the issue before the appellate court?
The issue was whether they are entitled
service.
to be governed by the old pension rules or the new pension rules. So as they had relied on the Fazle Rabbi judgment, the respondents saying that they're eligible.
In that case, their regularization was after the new pension act came into force or prior to the new pension act?
My lord, they were regularized in the year 2003. So the court held that they'll be governed by the old pension rules, but their entry into service will be counted from 2003 and not from 1993, when they were initially appointed against the non-sanctioned rules. That part is that particular.
Oh, that is a different thing. That's a thing that has to be counted from 2003.
Date of
Fine.
entry.
But here is a case, the petitioner's husband expired in service, died in harness. Then which law will be applicable?
My lord, that is what the department is right now in.
What right now? That will be applicable for all. If a person dies in harness, then what happens?
That case, my lord, 140 rule will
140.
be governing his case.
Then he will not get, she will not get pension.
She is entitled, my lord. She's completely entitled, but whether she'll be entitled under 140 or 142.
What is the difference 140 and 142? Read and tell us.
My lord, in 142, it says that if the government servant has rendered minimum of 7 years of service, continuous
Please,
service.
No, 1 year.
142.
142.
So
Then please
142.
proceed.
7 years continuous service dies while in service, the family of such government servant may be granted a pension at the rates and conditions mentioned below. So for a
Here the petitioners are from,
so my lord, if you count
it was regularized on 2006. It is from the date of regularization or from the date of joining, because remember, he was paid from a particular sanctioned post. It is not as he was working in a contingency,
he was an ad hoc appointment.
maybe, but against a post. If there is a difference, contingencies and the post, right? So there has to be only one secretary against each Gaon Panchayat.
Yes, my lord.
He was a secretary, so there is a post created for that, because earlier it was a board, thereafter came under all
Yes,
one
my
act, right?
Yes.
So then the service rendered by the husband of the petitioner from 1990,
94, my lord.
Yes.
you have no value to get the pension. That's what the Honorable Division Bench says it. I don't think so.
But the court has held that his entry into service will be counted from 2003 onwards. So the clock has to now
For the
start.
purpose of pension or purpose of new pension policy.
My lord, he'll be no doubt covered by the old pension rules. That is what the court held. But the entry into service will be counted from 2003. My lord, I'll just read the relevant para. My lord, and accordingly. Sixteen. Page 13, my lord.
Please read.
In view of above determination, this court has no hesitation in holding that the entry in the service of the petitioner, that is respondent herein as Gaon Panchayat Secretary and the government in PRI is required to be treated with effect from the date of issuance of consequential orders by the CEO in terms of the order dated 35/2003. So it has to be counted from 35/2003. The date of entry. So date of
What's on the
initial.
judgment?
I don't have copy.
No, data copy আছে।
Notes and.
Please take your seats.
No.
Please tell your colleagues that in the court they should maintain silence. We get 145. Mr. Pargiri, do you have the copy of the regularization of service of the husband of the petitioner?
My lord,
Just give it to us.
I have not annexed, my lord.
Do you have a copy or not?
No, my lord. Page 20, my lord, son, date of regulation 1/1/2006.
Order of regularization. Yes, you are giving us the date, but we are the order by which his service was regularized. Yes, tell us. What is the finding in the read appeal?
The finding in the writ appeal is that he will be governed by the old pension rules only, but his length of service would be, his date of entry into service would be counted with effect from 30th of May 2003.
Are you sure? Then why it has dismissed the read appeal and uphold the judgment of the
No, my lord, because
Single
the
judge.
contention of the state was that his date of entry should be with effect from 2006, because there were two regularization orders. One was in
then
2000.
why the honorable single judge judgment was upheld? Because the honorable single judge allowed the pension to the sole respondent in that appeal,
Yes, ma'am.
right?
The question is of date of initial appointment. So as far as the Syed Fazle Rabbi's judgment, the pension was to be reckoned from the date of initial appointment. So the date of initial appointment in this particular case would be, as per the interpretation of this DB judgment, would now be 2003, because date of
So as which para has said,
my lord,
final conclusion,
that is
so as final conclusion.
the judgment. Page 13, my lord. Page 13, para K. In view of above determination, this court has no hesitation in holding that the entry in the service of the petitioner, that is the respondent herein, as GP secretary under government in PRI, is required to be treated with effect from the date of issuance of consequential orders by the CEOs in terms of the order dated 35/2005. It should have been 35/2003, my lord. Actually, that's a typographical error. I can see para H in page 20.
Under which heading will you come back?
This is under Decision in Pranay Kumar Dev Supra and the communication dated 4/2/2006. Second one, my lord. Starting from page 10.
No, your page and my page will not fit it, right? But just give us the heading.
Decision in Pranay Kumar Dev Supra and the communication dated 4/2/2006.
You read which one to show?
Para H, my lord.
Yes.
Thus, from the aforesaid, it is clear that not only the government, without any ambiguity, regularized the services of the Gaon Panchayat secretaries by the communication dated 35/2003, but also admitted on oath in the proceedings of WPC 869 of 2003 that the services of the Gaon Panchayat secretaries stood regularized by virtue of the notification dated 35/2003. And then, my lord, finally, it was held in Para K that in view of above determination, this court has no hesitation in holding that the entry in the service of the petitioner respondent herein as GP secretary under government in PRI is required to be treated with effect from the date of issuance of consequential orders by the CEOs in terms of the order dated 35/2003. It should have been 35/2003, my lord, because if it had been 2005, then it would have anyways been.
Okay, we should read it 35/2003.
3, my lord. So the date of entry is to be counted with effect
From the date of issuance by the order by the CRI or CEO or from date 35.
That notification, my lord, in the same date was issued, my lord, 35/2003.
Okay.
Relying upon the recipe number 145/2009.
Yes, then. Date of entry, let us assume 35/2003.
Yes, my lord.
Right. The case in hand, the CEO's order was of 2006. 1st of January 2006, page 20.
Page 20, my lord.
Now, so in the case, in that particular appeal, the Honorable Division Bench found the sole respondent entry into services 30/05/2003. Right? Now then what?
My lord, in this particular case, it's 14 years, 5 months and 27 days. Anyways, the husband is qualifying under Rule 140, minimum 1 year of qualifying service is required.
It is there or no?
Yes, my lord.
Then
That we have agreed. So at the best, my lord, the petitioner is at liberty to file a representation to the PNRD department. We can verify the claims, pass on the papers to the concerned pension and grievances department, and they can finalize the same, because we at the best can only forward the papers, my lord, as PNRD. The rest is
Also,
in the
pension proposal
pension departments.
pending before the respondent
Discretion.
number 3, my lord. On that basis, my lord, unutilized leave encashment has sanctioned case 21.
Yeah, we have paid that, my lord, as far as PNRD is concerned. Unutilized earned leave.
yes, Mr. Gogoi.
Now issuing family. Director authority to have a consider the entire case and decide on that point instead of.
Husband of the petitioner was regularized.
Yes, 1/1
With effect from 1/1/2006. While in service, he expired on
2008.
15th of July 2008. So he has rendered almost
14 years from the date of initial engagement. From regularization is hardly 3 years or 2 years.
It's 1 years,
Yes.
15 days or 14 days.
For family pension, 1 year is enough for a regular employee. Otherwise, it will be 10 years. For such type of employee, it will be 20 years. For
So-
normal pension.
Is entitled for family pension.
Otherwise, my lord, it appears so. But even then, my lord, since my lord, the
We do not know whether she has submitted the
Yes.
relevant documents before the chief
I have-
executive officer, Jila Parishad,
lawsuit.
Morigaon.
MX my lord, pension proposal of case 14 my lord. Event of that time is on the proposal also now pending before the respondent number 3 my lord. This commissioner.
Then, my lord, the respondent 3 may, my lord, place it before the respondent number 5. Consider the same and do the needful.
But this is incomplete.
Okay.
Form 14 is incomplete, Mr. Padgiri.
My lord.
No date. Nothing. Whether this is the correct, because there has to be a forwarding. Where is that forwarding?
Test 14 below my lord, it is an initial my lord, chief executive officer.
There has to be a letter
My lord.
along with all the documents. This is not the one single form that has required to be filled out.
Forwarding letter.
There are 4 or 5 particular documents you need to place it, your Aadhaar, your PAN, your everything, then your photograph. This is not the form.
My lord. I may be allowed to file fresh my lord pension proposal.
What's your good name?
P. Handick on behalf of K. Goa.
Mr. K. R. Padgiri, counsel appearing for the petitioner. P stands for
P stands for Pavlov. P stands for Pavlov. PAVLOV.
Handick. Counsel for the respondent number 1, 2, 3, 4, and 6. Mr. D. Bora, Government Advocate Assam, for the respondent number 2 and 5, as well as Mr. B. Gogoi, Standing Counsel Finance, for the respondent number 7. Husband of the petitioner, Kumud Chakraborty, KUMUD, CHKRABRD, as well as KUMODE, CHKRABRD. Was the Gaon Panchayat secretary of Paliguri Gaon Panchayat in the district of Morigaon since 17/1/1994. On being appointed by the secretary, Morigaon Mahakuma Porishad Morigaon on 13/01/1994. The service of the husband of the petitioner was regularized, said Kumud Chakraborty was regularized with effect from 1/1/2006, being issued by the Chief Executive Officer, Jila Parishad Morigaon. Initially, husband of the petitioner received fixed wages at ₹900, which was subsequently enhanced. And from the date of his regularization of service with effect from 1/1/2006, he received regular scale of pay. The last posting of the petitioner was at Deokhal Gaon Panchayat, DUSAL, under the control of the Chief Executive Officer, Morigaon Jilla Parishad, Morigaon. Husband of the petitioner expired on 15/07/2008. Leaving behind the petitioner. In that regard, the Subdivisional Officer within bracket Sodar Morigaon, file number MAP.1/08/PT/71 dated 28/08/2008, issued next of kin certificate of in favor of the of said Kumud Chakraborty, reflecting the name of the petitioner as the legal heir of said Kumud Chakraborty. Being his wife. Within bracket likha, Tori Bar, Lisa Studio. Though petitioner approached the Chief Executive Officer, Morigaon Jilla Parishad, but the respondent authorities in the Panchayat and Rural Development Department accept paying her the leave encashment benefit of 154 days that stood in the name of her husband, late Kumud Chakraborty, paid an amount of ₹64,490 in that regard, without providing her any family pension. Hence, this petition by the petitioner filed on 18/06/2020. During the deliberation of the matter, Mr. Hendy, Standing Counsel PNRD Department, placed a copy of the division bench judgment dated 05/08/2023, passed in the appeal number 133/2023, State of Assam and 6 others versus Noor Hussain Mullah B. Submitted that the date of entry of the service of the late husband of the petitioner is only 01/01/2006. Has been issued by the Chief Executive Officer, Jilla Parishad Morigaon, on regularizing his assets from the same date. Right. Rule 140 of the Assam Pension Rules, the statutory rule under Article 309 of the Constitution of India, provides that except as otherwise, page number 81, what are the citing here? Such and such. Mr. Padgiri, on the other hand, submitted that the Chief Executive Officer, Morigaon, submitted the pension proposal before the Commissioner, Panchayat and Rural Welfare Department. For granting family pension, for award of family pension to the petitioner. However, and to that extent, Mr. Padgiri placed the communication of the Chief Executive Officer, Morigaon Jilla Parishad, Annex 3 to this petition. However, it is seen that the same is without any forwarding on the next date fixed. The Chief Executive Officer, Morigaon Jilla Parishad, Morigaon, respondent number 5, not 5, 6, shall apprise the court as to when they submitted the necessary family pension proposal of the petitioner before the Commissioner, Panchayat and Rural Development Department. It is made clear that India event the family pension proposal of the petitioner is not forwarded, submitted before the Commissioner, Panchayat and Rural Department for its onward submission before the Directorate of Pension, the Chief Executive Officer, Morigaon Jilla Parishad, shall do the needful by collecting all the requisite applications, forms, photographs, and other requisites for the purpose of pension of payment of family pension of the petitioner, of collecting her photographs, signatures, wherever is required. For that purpose, the petitioner shall appear before the Chief Executive Officer, Morigaon Jilla Parishad, Morigaon, on or before 8 of September. Based on 14/09/2028, sorry, 3, enabling the Chief Executive Officer, Morigaon Jilla Parishad, to place the up-to-date status regarding the submission of family pension proposal before the Commissioner, Panchayat and Rural Development, list accordingly. As this order has been passed in presence of counsel for the petitioner, as well as the standing counsel for the PNRD department, no comment has to be issued today. All right.
Please, Your Lordship.
My lord, we have received the instruction today morning. We need some time to file an affidavit, my lord.
What's the matter about?
My lord, the petitioner was appointed as a senior assistant, my lord. After the district scrutiny committee has sent the name of the petitioner as senior assistant, but the same was not considered, my lord, subsequently. Although the post of the senior assistant was ought to have been created by dint of or Act 2011, my lord, but the same was not created, my lord. As per the last order, my lord, the respondent number 3, that is the director of the secondary education, was directed to file affidavit as to why the post of the senior assistant in the Belgrade Higher Secondary School was dropped, though that during the course of the Act 2011, my lord, there was a requirement of the one post of the senior assistant in Provincial Higher Secondary School, my lord, as per Act 2011, my lord. They were directed to file their additional affidavit on or before 19th of August, my lord. It was directed on the last order, my lord.
What is your instruction?
My lord, I haven't gone through. I have just received in the morning while I was inside the court, your lordship.
Who has given you the instruction? The director or inspector?
From the director, your lordship.
Administrator, what's your good name?
A. Rishid.
For the petition. And Amnesty Tengarampi, Planet Standing Council, Department of School Secondary Education for the responding numbers 1, 3, and 4. And Mr. Bigo for Standing Council Finance for the respondent number 2 and 5. And Mr. At Council for the respondent number 6. Any idea, Mr. what happened with that the earlier repetition of the Zahirul Islam? So the principal will be knowing what happened.
No, that was disposed of, my lord.
Then what happened? We know that was disposed of.
Thereafter, it was the.
We want to know
My lord,
only that.
it was, my lord.
There was a
written
direction
on the
from
last
the
order,
court
my
to
lord.
hear you and that. Zahirul
Yes,
Islam.
my lord.
Then what happened?
Thereafter, the prayer of the Jahirul Islam was not, was rejected, my lord.
By which order? Do you have a copy of that order?
No, no, my lord. But my lord, it is mentioned in the additional affidavit filed by the respondent number 3, my lord.
That is what,
Yes, my lord.
you are the one of the person therein. Definitely that copy has been forwarded to you also.
No, my lord, it was not provided.
You could have collected it. That would have been easier for us.
Yes, my lord. In the affidavit at page 40, my lord, they have mentioned it. Answering department rejected the claim of the Jahirul Islam for provisionalization by order dated 11/11/14.
Whether this decision of the Director of Secondary Education Assam
Yes, my lord.
has been challenged anywhere? Is it any writ petition pending?
No, my lord.
Whether that person has filed any writ petition against this order?
No,
Are you
my
aware?
lord. No, my lord.
Are
We
you
have
aware
no
or
idea.
not? What is the order of provincialization?
At page 31, my lord. Except 5, page 31.
Next, sir.
5,
Page
31.
There are copy it. Pass the order to. Standing Council, Department of School Education. Please take your seats. Secondary Education Department, that's number 1. Mr. The Global Standing Council Finance for lesson number 2 and 5. Well, Mr. Who was there in the sorry, number of the council for the lesson number 6. The detailed order was passed earlier on 01/08/2023, pursuant to which the Director of Secondary Education Assam was directed to file additional affidavit in the matter. It is submitted by Standing Council, Department of School Secondary Education, that necessary instructions have been received and affidavit pursuant to the state order dated 1/8/2023 shall be filed shortly. In the affidavit filed on 29/05/2023, the Director of Secondary Education Assam categorically stated that pursuant to the order of the court dated 01/08/2014, passed in WPC number 3644 of 2014. After hearing the petitioner of said WPC number 3644 2014, namely Zahirul Islam, and the respondent number 6 therein, the present petitioner, Abdul Kalam, the Directorate of Secondary Education Assam rejected the claim of said Zahirul Islam on 11/11/2014. In the said affidavit, the Director of Secondary Education Assam also stated that on 05/06/1998, the principal of Belguri Higher Secondary School, Dhubri, appointed the petitioner as a senior assistant, while the said higher secondary school was in venture stage. And pursuant to the same, petitioner on 05/06/1998 itself joined his service as senior assistant of the said higher secondary, Venture Higher Secondary School, said Venture Higher Secondary School. In this 8th affidavit, Director also stated that the principal of the said Venture Higher Secondary School submitted the proposal for provincialization of both teaching and non-teaching staff in the name of such and such of the said higher HS school, including the name of the writ petitioner as senior assistant for provincialization of their services under the Assam Venture Education Institutions Provincialization Act 2011 as amended. And that the said proposal was approved by the District Scrutiny Committee, Dhubri. As such, the name of the petitioner was duly recommended by the District Scrutiny Committee for the post of senior assistant for recommended for post of senior in said Belguri Higher Secondary School or provincialization of service under the said 2011 Act as amended during its course. Today, during the deliberation of the matter, Mr. Mandal, Council appearing for the respondent number 6, placed a copy of the said order dated 11/11/2014, passed by the Director of Secondary Education Assam, rejecting the case of said Zaharul Islam and allowing the case of the present petitioner for the post of senior assistant in said Balgori Higher Secondary School. It is seen from the said order dated 11/11/2014 of the Director of Secondary Education Assam that said Zaharul Islam was serving, that said Zaharul Islam is a junior assistant of the provincialized Belguri High School, and the upgraded Belguri Higher Secondary School was provincialized with effect from 1/1/2013. No, it was not. The said Belguri Higher Secondary School permission to open said Belguri High Secondary School was concurred only granted only on 18/09/1996, and the upgraded portion of the upgraded Belguri Higher Secondary School was provincialized by order dated 30/08/2013 with effect from 1/1/2013. Belguri High School was provincialized in the year 1991, including the service of the said Zaharul Islam as its junior assistant, as its grade 4 employee. And later, said Zaharul, and he was upgraded to the post of LD assistant on 15/10/2004. Said Zaharul Islam was claiming for the post of senior assistant in said Hansa Belguri Higher Secondary School, though his service was already provincialized in the year 1991. As such, finding that said Zaharul Islam serving as junior assistant, provincialized junior assistant in the provincialized Belguri High School, the district scrutiny committee did not recommend the name of said Zaharul Islam, and rather recommended the name of the petitioner for the post of senior assistant in the higher secondary section of the Belguri High Secondary School, considering that the service of a provincialized employee cannot be recommended again for provincialization. As such, after hearing Said Jahirul Islam and the present petitioner, pursuant to the order of the court dated 01/08/2014, passed in WPC number 3644/2014 within bracket Jahirul Islam versus Dr. Osam and others. Rejected the claim of Jahirul Islam for his appointment as a senior assistant in the higher secondary section of the said Belguri Higher Secondary School. Very little. Answer has been decided. From that, it is clear that the recommendation of the District Scrutiny Committee recommending the name of the petitioner for provincialization of his service as senior assistant in the Belguri Higher Secondary School was pending for consideration before the state level committee since 11/11/2014, where the Director of Secondary Education Assam was the secretary of the state level committee for approving approval for necessary approval for provincial level services under the said 2011 Act as amended. Considering those aspects and in terms of the order passed earlier on 01/08/2023, the Director of Secondary Education Assam shall file its affidavit without fail on or before 15th of September, released on 19th of September. Mr. Gogoi, there will not be any escape.
Other than a treasury, yes, no worry.
True, but be there as a finance department, we'll see, because you file application for improvement of finance department. Immediately. You have to pay. Because whatever bill you are there, you're spending. You have to pay.
Right, please, my lord.
Yes.
Matter pertaining to my lord, risk and hardship evaluations to the battalion, my lord. My lord, at the point, initial point, at the time, my lord, they were, my lord, 9,700 was my lord granted, my lord. Then my lord subsequently.
Yes.
Lordship, the report of subcommittee is still awaited. The matter is under consideration of subcommittee constituted by Ministry of Home Affairs.
Since when it is pending?
Yes.
The subcommittee was constituted on 6 December 2022 by Ministry of Home Affairs.
Last 8 months, my lord. My lord, maybe dispose of to give a direction to, my lord, within 1 month there to, my lord, consider. Because my lord, some are, my lord, required, my lord, and their gratuity
Matter
also.
relates to drawal of risk and hardship allowances.
Yes, Lord.
Yes, my lord.
By the petitioners who served in the Central Armed Police Force and Assam Rifles.
Not, my lord.
Not on the
20
Central Police Force. Your good name, Medhi, right?
KK Medhi, on behalf of SKM. In item number 31, Lordship.
submitted. That, do you have that communication of the Home Department?
Yes, Lord.
It is placed before the court that the Ministry of Home Affairs, by its office memorandum dated 06/12/2022, constituted a committee for review of classification of field areas and that the cases of the petitioners have already been placed before the said committee It is also placed before the court that the cases in hand is under active consideration, effectively, of the said committee for review of classification of field areas. But the report from the said committee is still awaited. In that regard, Mr. Medhi, Lanet CJC, placed the communication of the DIG administration the department concerned dated 04/07/2023 communication from the office of the IGP, NES within bracket PAIRVI, PAIRVI cell at GC, CRPF Guwahati dated 06/07/2023. Along with the communication of the DIG Central within bracket administration, DT dated 04/07/2023. Under numbers J dot Roman 2, capital Roman 2, dash 45 of the 2021 dash NES dash PAI RVI, as well as number A dot I Roman I, capital Roman I, dash 3 oblique INSTN instructional INSTN dash accounts ACC PS dash 3 within bracket RHA respectively. Considering the same, these repetitions are disposed of. The observation that the cases of the petitioners will be subject to the outcome of the concerned committee for review of classification of fleet areas constituted in terms of the office memorandum dated 06/12/2022 of the Home Ministry of Home Affairs. However, till such decision of the said committee constituted by the said office memorandum dated 06/12/2022, the respondent authorities shall not recover the risk and hardships allowances already paid to the petitioners. It is also made clear that if the petitioners are agreeing with any such decision of the concerned committee constituted on 06/12/2022, they may approach the appropriate authority. Against such. Alrighty.
My lord, if wrongly paid also, my lord, there is judgment, my lord, they have not, my lord, recovered.
Any order, you can always approach. Hello.
May I please your lordship? I'm for respondent number 7. In this matter, 2 weeks time may be granted for taking instruction. For the first time, we have appeared as a legal aid counsel. I'm on behalf of R. Islam. He is on legs on court number 15.
Number 7 is the second one, my lord. Petitioner is the first type, my lord. Initially, respondent number 7, my lord, filed the pension proposal papers, my lord.
That's no. Mr. Patiri,
My lord.
the finance department is a party here.
Sorry, my lord. Not made a party.
A party application. He expired in 2011.
My lord.
We are in 23.
My lord.
Without the finance approval, it cannot be conducted. It will be a delayed pension, right? Whoever gets that will be issue.
Chief, I'm representing respondent number 1, 3, and 5, my lord, and I have filed my affidavit on 2/6/2022. my lord.
You are appearing for?
For respondent number 1, 3, and 5, my lord.
Good. 1, 3, and 5.
Yes, my lord.
Soil conservation
Then
department.
please answer. Come
My-
to,
My lord, actually, the second wife, she had applied for provisional pension, my lord,
that we know.
and my lord,
Your affidavit. Kindly
My-
answer.
my affidavit, my lord, on 2/6/2022, my lord.
That's what we know.
Yes, my lord. Page 6, my lord.
You come to Annexure 5.
Yes, my lord.
What happened? This is a letter of 3rd October 2018. What decision you have taken? What decision you have taken?
Lord, due to my lord that the pension paper is in the accountant general office, my lord, and we,
This has come from the Accountant General only.
My lord.
yes, my lord.
Stated through India.
So, my lord,
Only when you will write
My
it back, they will do it.
yes, my lord, but petitioner, my lord, she have to submit, my lord, proper documents, my lord. She have not annexed to our.
Have you communicated to the petitioner?
Yes, my lord.
When did you communicate to the petitioner?
That instruction I will get, my lord.
What instruction? As of now, we have not stated anyway. When did you instruct directed the petitioner to submit all those
I will
documents?
take new instruction, my lord.
What affidavit you filed?
Well, that's
In
just
your application, you have already admitted the fact that you are the second wife.
yes.
And there are certain mentions in the writ petition that both the petitioner and the respondent number 7 are living together cordially.
Well, what had happened, just I have to take instruction, but I am, as a legal aid counsel, I have been.
True, that's what.
The first wife, due to the mental disorder of
No,
the
no,
first wife.
that in fact, there is a letter here from somewhere, somebody has placed it here.
Yes.
That there is nothing like that. And do you deny the fact that you are the second one?
That's, I'm not denying.
If there is a
Admittedly.
first wife, let us assume like this. The respondent number 7 somehow will manage a next of kin certificate showing the legal hair of Surya Varman.
Yes.
Right. So when then she will get the pension?
No, no. Because my lord, in the legal hair certificate, the first wife name is also there. As per the petition, I have gone through the same. First wife name also there. Due to the mental disorder, my lord,
It's okay. Then it's a
that's
different
the
issue
only issue. But the second wife has a daughter, my lord.
She will get some part. That can
She
be
is
different
minor.
order.
Otherwise not entitled, my lord, as per pension rules, 143.
Second wife not entitled.
Mr. Patri, file your application.
My lord.
For implement of your finance. Khalifa or Mr. Chair for the council appearing for the petition. MS RDV Standing Council Soil Conservation for the respondent number 1, 3, and 5. As well as who's government advocate? You are referring to? Why are you referring to the government advocate?
Islam.
Sorry,
Haris.
Islam. Legal aid council is under reference on behalf of the respondent itself. The prayer of Mr. Islam. Please this matter on 14th of September. In the meanwhile, the respondent number 7 shall file its affidavit. You also file, we are not mentioning it. My lord.
Much obliged.
Next, please. Lord, item numbers 33, 36 to 40, my lord, I'm appearing. 34 and 5, my lord, I'm appearing. But so far as these items are concerned, my lord, 32, 36 to 40, my lord, they pertain to termination of a junior engineering assistants with the Indian Oil Corporation. There, my lord, pleadings are more or less complete, my lord. We've also filed a rejoinder. Now, perhaps some clarifications on the affidavit filed by the IOCL may be required in my understanding, my lord. Because, my lord, the issue here is that I was terminated without an inquiry, my lord. I had absolutely no clue, my lord. And I was suddenly, after 1 year of my joining, I was served with a notice saying that an internal investigation has been carried out, where I was found that my appointment itself was erroneous. Now, although they have relied on that so-called internal investigation where I was not a party owner, the investigation report, none of that has been enclosed.
Can you just tell us if the appointment is erroneous, they have found on what ground?
Well, they have said, my lord, basically, so far as item 33 is concerned, my lord, there was an issue regarding age relaxation. There were other candidates whose candidature was rejected, my lord, on the ground that they were overage. My lord. Those candidates, my lord, they filed two separate writ petitions, 34 and 5, my lord, where they say that they ought to have been given 2 years more of relaxation insofar as age is concerned. That
with regard to you?
With regard to me, my lord, they did not say. With regard to me, they said since I have availed 2 years, they were additionally entitled to 2 more years of age relaxation. Of course, that's a subject matter of item number 34 and 35, my lord. There, my lord, IOCL initially said that, supported my stand and said that they're not entitled to that additional age relaxation.
Those two petitioners of those two petitions?
Yes, my lord. There, my lord, the petitioner in 32 is a private respondent. Now, thereafter, my lord, subsequently, we've seen from the records that the same officer who had filed the affidavit saying that the petitioners in 34 and 35 will not be entitled to that additional age relaxation. Now they have contradicted their stand and they've filed another affidavit, my lord, the same deponent, who's saying that no, they should have been granted that age relaxation. So that stand is
now, because they have come to the finding that the petitioners of those two writ petitions are entitled for
Age
additional
relaxation.
2 years of
yes,
age relaxation. And
Yes.
in that case, you cannot be appointed. And do they
that is their stand, my lord. Now, of course, my lord, 34 and 36 to 40, my lord, they're altogether separate, my lord. The termination orders are even dated, my lord. But there they've come up with some other additional grounds where they've said that there has been a miscalculation of the OMR sheets, my lord. But the appointment, the recruitment itself was done way back in 21, my lord. Now, suddenly, after more than 1 year of service, my lord, these termination orders were issued. And
what's wrong? Why it is wrong? Where you see?
my lord,
If
because
the OMR seats
my lord,
come to be,
my lord, at least I have to be put to a notice, my lord. Absolutely nothing, my lord, not even a notice, my lord. And now they've come up.
Whether the OMR notice were uploaded
My lord, marks were uploaded, my lord. I had completed my probation period. A few of them were also given increment, my lord. And suddenly, my lord, we were served with a notice. Now, my lord, that notice itself, termination letter, my lord, itself says that there was an internal investigation conducted based on some CVC complaints. But I was not privy to that, my lord. No notices were served, my lord, which is, and in fact, if your lordship sees the affidavits file, my lord, here also, they've not annexed what the investigation was all about, because only complaint was with respect to the petitioner in item number 33, which is age relaxation. And that was a matter which is sub judice.
That is different.
My lord, but now they're trying to correlate to say that when we first encountered that complaint regarding age relaxation, we conducted an inquiry and we also found these other 5 to be illegal, erroneously appointed. That's the word we use, my lord.
Erroneously appointed on the ground of their answers were not correct.
The numbers, for some, they said numbers were not telling. Some, they did not even cite a reason. Two, of course, they said OMR sheets, there has been some miscalculation. In respect of the others, my lord, they've said erroneous selection. What is the ground? Nothing is known, my lord. Now, my lord, of course, their stand is that I am a probationer, therefore I'm not entitled to a notice. Now, of course, that we are all aware, my lord, if they've conducted an internal inquiry, my lord, I should have been given at least a notice. If they have chosen not to extend the probation period, that's different, my lord. But so long as it's stigmatic and it says that I had the termination letter, though it may seem innocuous, it gives the impression as if I had indulged in some malpractice of sorts. So in that case, my lord, and additionally, if they've then done an internal investigation, I'm at least entitled to a notice, my lord. Now, one thing I'll just quickly show, my lord, if your lordship takes up the affidavit in opposition.
Just a minute. Let us hear from Mr. Chaudhary. You are appearing for IOC?
I am appearing for IOC.
No, see, as you know, the law is well settled. If somebody's appointment is not erroneous, not in the sense, not erroneous, fraudulently, or doing some wrong, submitting some fake certificate, for them 311 notice not at all required. But if it is a case that you find it later on that you should not have been appointed or not have been appointed for this reason or that reason, after rendering certain period of service, even if it is a provision, if it is strenuous, then you have to issue notice.
That is where is the
But the law is settled by the court.
exactly. Law is settled that if you are a probationer and if you have been terminated without attaching any stigma, then there is no notice required. The law, I can place all the judgments. The facts are like this, my lord. Let me clarify on the facts.
We'll come back to you, but after hearing Mr. Dekar and Mr. Patel, but thing is this, those cases where you are saying where provisioner can be terminated, it's relating to because of their service, some kind of things are there. There is no such decision you'll find probably where a person has been appointed due to mistake of the employer. Let us assume because here the OMR seats have been corrected by you. So if it is somebody has been appointed, the wrong of the employer, even he is a provisioner, can he be terminated?
Yes, that is our whole case. That is our whole case. The law is, as has rightly fallen from your lordship, if the entry is incorrect, your lordship is aware, the law is well settled. There is no question of any 300 protection of any 311. So that aspect is already there. Just to give a brief background of the facts, what had happened was after the selection was conducted, these two repetitions, Rahul Das and Prashant, two persons, they lodged complaints saying that we have been erroneously ousted because we were entitled to these kinds of relaxations, etc. etc. These complaints were lodged. Two repetitions also get filed. Once these repetitions get filed, the authorities in IOC, they decided to conduct an internal investigation with regard to the entire selection process. Once we conduct the internal investigation, this is in the nature of a preliminary inquiry. And I'll place judgments to show that if it is on the basis of a preliminary inquiry, there's no question. If we might decide to stop at this stage of the preliminary inquiry and say that we are not going to conduct any disciplinary proceedings against the parties concerned, and we will simply terminate their services since they are probationers. That is the law. I'll place those judgments. Now, during the course of the internal investigation, it was found that not only in respect of these two petitioners, there were other anomalies. Therefore, the investigation was handed over to the CVC. CVC conducted, again, it's an external agency. We thought that it is best if it is conducted by an independent agency. CVC does its investigations and says that not only in respect of these two posts, this particular post, but also in respect of these XYZ other posts, there have been anomalies, there have been some manipulation of marks, etc. So CVC made twofold recommendations. First recommendation, that you haul up the officers who are responsible. Proceed against them, which we have done. Second, it said that since these appointments are erroneous, you take a call on this. So, in terms of the settled proposition of law, that they
erroneous on the ground of what?
That they were, like for example, this Rahul and Prashant, two of the petitioners, they, although they had got higher marks, otherwise they were held to be, the relaxation that they were entitled to were not even granted. Now, in respect of another set of persons here, there were marks which were, there were interpolation of marks. There were manipulation in marks. So these things, because of which, otherwise they were not entitled to be appointed. They were not entitled to be selected. But they got selected because of these interpolation of marks, etc., etc. So therefore, we said that, all right, we will not attach any stigma to you. We will not conduct any disciplinary proceedings. And in terms of the settled proposition of law with regard to probationers, we said that we issued a termination simpliciter, and we said that your services are terminated. That is how it factually it stands. Of course, I'll have to take your lordship through a whole lot of documents.
Now, one thing just tell us, after declaring the results, okay. Now,
in fact, if your lordship will allow me, I will quickly place the appointment order. That will make the position very clear. If your lordship will kindly have the appointment order for a moment. Page 34, your lordship will kindly take up 1069 of 2022. Your lordship will straight away come to page 34. This is the order of appointment. It's a very detailed order of offer of appointment. It's dated 27th of December 21. And if your lordship kindly turns to page 35, clause 3. You shall be on probation for a period of 6 months from the date you join the post, which may be extended or reduced depending upon your performance, application, attendance, verification of character and antecedents, caste, and bearing at the sole discretion of the management. If your work is found to be satisfactory during the probation period and verification of your caste certificate applicable, etc., character and antecedents are also found satisfactory, you may be confirmed in service. Now, next sentence is very important. Your services will not be regarded as confirmed until a letter of confirmation is issued by the management. If I may pause here for a moment, Malak. It is the petitioner's own case that there is no specific order of confirmation. So therefore, they continued in probation. Next one. Your services can, however, be terminated at any time during the probation period without notice or assigning any reason whatsoever. Now, thereafter, my lord, if your lordship will kindly come to clause 23 at page 38. you can be removed or dismissed from the services of the corporation at any time without following laid down procedures of disciplinary action in case you are convicted of a criminal offense or a grave nature in a court of law, or where the director, executive director, general manager is satisfied for reasons to be recorded in writing that it is neither expedient nor in the interest of security to continue in the services of the corporation. So basically, the main clause is clause 3. And these are the two sources of power that we have. And this is strictly in terms of the settled proposition of law relating to probationers. The Lordship is aware, there are a catena of judgments right from the 60s that a probationer does not have any right per se to claim continuance.
Where is the advertisement?
The advertisement is at page 16.
Is there any recruitment rules?
Well, there is a set of standing orders. So far as the rules, etc., are concerned, there's the advertisement itself covers everything. And in respect of this Rahul and Prashant, the problem arose because of page 20, Madam. Page 20, clause G, capital G. The Lordship will first come to subclause 3 thereof. Relaxation in age up to 5 years for SC/ST and 3 years for OBC and CL candidates considered against the reserved positions will be allowed. Now, next clause, subclause 7. Period of apprenticeship training under so-and-so in an industry covered under the experience criteria notified in this advertisement relevant to a post will be considered for relaxation in age. Age relaxation, next clause, subclause 8. Age relaxation of a period equal to minimum years of experience notified against a post shall be allowed. Now, erroneously, they were not given this relaxation. And had they been given the relaxation, because they have otherwise got higher marks, just to indicate, my lord, this Rahul.
In that case, only 2 candidates will be in.
I'm sorry.
In that case, only 2 candidates will be in.
So far as the eligibility is concerned, and on marks, just to indicate to your lordship, actually, the petitioner has got 73 marks. And the other person, Rahul, who initially lodged the complaint and also filed the writ petition, he has got 93 marks, 20 marks more. So obviously he would have got the job.
So 2 persons will be out and 2 will be in.
No.
In that case.
In this category, junior engineering assistant 4, Rahul will be in on account of his higher marks and
experience.
He will be out. So now, once this kind of a position arises, and especially when an independent agency like CVC tells us, gives a recommendation that firstly, the officers responsible for this, you proceed against them. And secondly, so far as these erroneously appointed persons are concerned, you take a decision on it. And naturally, the only option that the authorities would be left with would be, since they are on probation, continuing on probation, there is no express order of confirmation.
But if it is not at the fault of the petitioner, then
Even then, since it's a probation, and that is what the law says, if rightly or wrongly he is not entitled on account of his lower marks, he has got the job on account of, it may not be attributable to him, but on account of a mistake, whether bona fide or mala fide, we will find it out during the course of the disciplinary proceedings against the officers. But rightly or wrongly, there has been a mistake and he was not entitled to get the appointment. And therefore, in that kind of a situation, how does one deal with a probationer? Issue an order simpliciter so that it does not affect his future prospects of employment. And there's no question of any disciplinary proceeding here. 311 will not even be attracted. And even a question of notice, there are several judgments which I can place, that the principle of law is like this, Malud, as I have understood, subject to correction. The principle is like this, that many situations during the course of a probation period, many situations may arise. For arriving at a prima facie satisfaction, we can do a preliminary inquiry, or whatever name we call it, an internal investigation or a preliminary inquiry. And if there is even an iota of satisfaction, it might be very prima facie. Even then, we have, at that stage, we have two options. Either to conduct a full-fledged inquiry. That is when, to impute misconduct, we will have to conduct a proceeding, put him to notice. But if we issue an order simpliciter, the requirement of notice gets done away with. So in a nutshell, my lord, that is
another thing just clarify, because we'll be hearing Mr. Dekar later on. The appointment order,
my lord,
at page 34. Clause 3. You have mentioned that
the last two sentences are of utmost relevance.
Your services will not be regarded as confirmed until a letter of confirmation is issued by the management.
My lord.
But if you look at the first line,
my lord,
probation is for 6 months.
My lord.
Does it mean that the service is confirmed, the person concerned will remain on probation after 6 months?
Yes, that is the law. That is the law, which was settled way back in 63. Dhingra and all those cases.
That background is of course little different. The Dhingra's,
No, but in my respectful submission, that is what has been conclusively held by the apex court, that there is no concept of deemed confirmation. Deemed confirmation arises only when an outer limit is put and the rules provide for a deeming provision. But here, it has been expressly provided that you will be confirmed only when we issue an express order confirming. And that is also settled. If your lordship so desires, I can place judgment straight away.
Come back to it.
So, in fact, my lord, this proposition has been conclusively laid down in Dharam Singh's case. Dharam Singh, 1968. Absolutely categorically laid down that there is no concept of automatic confirmation unless the rules themselves provide. And here, not to speak of any rule providing, it has been made very clear that confirmation, although 6 months has been mentioned, confirmation will happen only on issuance of an express order of confirmation. So, on each of these points, my lord, the law is pretty well settled. And if your lordship looks at the order of termination, we have not attributed
that you have seen.
Not even an iota of stigma.
But the petitioner is probably because of some inquiry internal without giving him an opportunity.
Because that is again the law, man. If there is a preliminary inquiry or something in the nature of an internal investigation, he is not required to be put to notice. Only when we decide to conduct a full-fledged inquiry, that is when.
But if the rule doesn't provide for any re-verification, can you do that? That's why we're asking you the rules. The rule is silent regarding re-verification.
There is no question of re-verification here. There has not been any re-verification.
No, because
there has been an investigation.
Two issues are there. One issue is that not considering the case of the other petitioner who should have been considered, or to have been considered and could have been appointed. This is another issue. Now, you made it a internal inquiry, giving it to a private agency, not private, an authorized agency to look into it. Then they found some of the persons have been, you are saying manipulated, but whatever the OMR sheet, whatever result is there, it's there. Now, if in the OMR sheet, the question of manipulation will not be there. Only the thing is the calculation will be there.
Calculations.
Right? So in the OMR sheet, if it is the calculation is there, the marks have to be probably might have been discussed, already been notified, or maybe in the website you might have published it.
Yeah.
So if after some time, if somebody has joined and something, case of this other person may be different. That should have been not to have considered. But regarding re-verification again about the marks, the calculation part, after some time means after 6 months or 10 months or something, which may be occurred after 1 year, 2 years, till the confirmation is given. Can you do that?
May I straight away answer this one? What happened in the APSC cases in Assam? After 3 years, 4 years.
It is because of the involvement of money came in.
No, it does not matter. Let us assume that there is no money involved. What had happened? In APSC, after 3-4 years, someone lodges an FIR in Dibrugarh. Based on that, an entire investigation process starts rolling. During the course of the investigation, various things come up, manipulation, and exactly like in this case, I am aware of certain facts because I am appearing in some of the matters there also. Similar manipulations have taken place. Marks were increased, in some cases marks were lowered.
How can it be if it is in the OMR sheet?
That is what has come out in the investigation. What had happened was, someone assuming while calculating ought to have got 75. By making some additions here and there, that 75 was made 85 or 90, just to bring in. And there, as has rightly fallen from your lordship, there that additional angle of money changing hands had also come in. But assuming money had not changed hands, during the course of an investigation, such serious things come out.
That's of course.
So, and in the APSC case, exactly identical situation, this honorable court has upheld those terminations.
Any appointment, it has to be valid.
Exactly.
So that is a different angle from that, for which you can of course happen definitely. But here is the case of the petitioner is regarding any such giving him an opportunity. That will come.
That matter I can satisfy your lordship. There are several judgments. Of course, all these things ultimately, although it tends to get a little gray at times, that concept of motive, foundation, what would constitute motive, what would constitute.
Now, after you have re-verified whatever the CBC's report and you found certain, some candidates around.
Yeah, that is the other thing I wanted to point out. If your lordship will come back to the advertisement for a moment. If your lordship will have page 16 for a moment. There is a chart at page 16. And if your lordship kindly sees the number of vacancies, in the fourth column, your lordship will see to find total. And against that, your lordship will just total
C, D, E, F, G, which one?
D1. That is the total number of vacancies. 28 in respect of one post.
Breakup is on the right side.
Yes, we are not concerned with the breakup. All I wanted to point out was 28 plus 3 is 31, plus 4 is 35, 4 plus 5, 50, 40, plus 4, 44 posts. The recommendation and termination has been done only in respect of 6, 7.
Now,
it is not.
We're not saying that. We're not totally, but if these 7s are out, some 7 has to be in.
Exactly. Like in case, there after, once this is taken care of, what will happen is, in case of these 2, they are before your lordship. Your lordship may perhaps like to remand the matter back to the authorities, saying that you consider afresh. And insofar as the other who will be out, either we will have to conduct a fresh selection, or we'll have to look up as to who would have been actually entitled, and then call it. We will be left with only those two options. But in respect of the other posts, the other persons are not before. Like Rahul and Prashant, the other concerned persons have,
because seeing their marks, they may not have come.
they perhaps
But
do not, they perhaps do not even know that they will.
Exactly, these cases are.
So their
equity is on the employer.
So we will be left with either of these two options, either to go back to that stage and find out who would actually come in, or to conduct a fresh selection. Therefore, my lord, these matters will take, if we go into all those aspects of motive, foundation, etc., I think these matters are likely to take some time. I am at your lordship's disposal, my lord, if your lordship wants to commence today and continue follow the.
In fact, somewhere to start it, right? Have you prepared a chart?
The chart of the
petitioners.
I have a rough note, Manoj, but not conducive to be handed across the bar.
Because
I can prepare a chart, Manoj, but
that thing will be required. You see the advertisement, then you give the date of the selection, the marks you obtained as per the result, then appointment and then termination.
Then termination and the ground for the
Ground is already there in
Already
your
there.
termination letters, right? That will be required because.
And
have to
perhaps
verify-
your lordship also has to take up 34 and 35, because the issue of age relaxation, which is shown as a ground for my termination, was already sub judice before the court. And it's a complex matter of interpretation. There may not be a right or a wrong, stricter sense of it. That the court was considering. And while the matter was sub judice, my lord, they seem to have made an inquiry. Although they were supporting my stand initially, my lord, then they took a volte-face and said, no, we must have committed a wrong. Whether they were entitled to that age relaxation or not is a subject matter to be decided in 34 and 35. Because there again, if we are out from the reserve category, they may possibly be considered under the general category also. That is, of course, a subject matter of 34 and 35. But without waiting for that, for the outcome of 34 and 35, they carried out a slew of termination.
The internal inquiry, they found that your marks. also
What they
manipulated.
found exactly is not before the court. They have not even annexed the investigation report.
See to that. Prepare a chart and give it to us.
Hello.
In all the matters,
All are interconnected.
All are interconnected.
And pursuant to the same advertisement.
Well, I am appearing in item 34, Rahul Das, and there, my lord, why order dated 28/2/2022. His appointment has been made subject to outcome of my request.
Yeah. 21st.
21st. Who is appearing for 39 and 40?
Hello, I'm-
All you are appearing, right?
I'm appearing except for 34 and 35 rest I'm appearing.
34, 35.
35.
In item number 35.
35.
Miss Mahanta. Mr. Raichowdhury, Senior Counsel. The IOC. You are assisted by whom, Mr. Chaudhary?
Miss Tanishka Singh.
According to this proceeding, I've already since their affidavits. No formalities that we have. প্রথমত issue no formalities the party that are different. Release this matter for hearing on
If it is not inconvenient, can it be 21st, my lord? My friend, it is, I have checked up with my friend also, 21st of September.
Admission hearing.
Okay.
21st.
Come up for admission hearing.
Straight away for hearing the top of the list on 21st.
Your lordship has admitted this matter.
Your lordship is also observed as top of the list. Take the apply.
Yes. 42 na 41.
41 more
Lordship.
Yeah.
42 is a different matter. Lordship, for item number 42, I am appearing, Lordship. And in this matter, I am appearing for a respondent, water issues department, Lordship.
42 is the
Different matter, Lordship.
This
And-
will be segregated, Lordship.
And we have received instructions, Lordship. May I pay for 3 weeks' time to file the affidavit?
Give us a date, Mr. Das, when shall we fix it?
Lordship,
Give us a date, when shall we fix it, and by which date you will file your affidavit?
within 3 weeks, Lordship.
Give us a date. You see in the calendar, give us the date accordingly. we'll fix.
Lordship.
That you will file your affidavit by that particular date.
Lordship.
23rd,
24th.
20. By 28th, Lordship, 28th September.
Okay.
42 to Belak.
Mr. RM, this council is reading.
number to भूल है 1996
Respondent water issues department.
1C91 है
That.
आपका number to 1996
Respondent 75.
यहाँ तो number to 169 I can এইটো আহিব লাগিব একো নাই মই এখনো
So you'll be filing on or before 28th.
Lordship.
Based on 2809. In the meanwhile, the petitioner may file his reply if any. With regard to said affidavit of the respondent of the issues. Okay. That takes care of 42.
So for item 41 is concerned, let's say.
42 likha hota hai.
Yeah.
This
Sorry.
petition, the issues involved in this petition is not similar to that of the WPC number 1694/2023. As such, this may be segregated. This shall be segregated from WPC number 1694/2023. How come it has been which?
My lord,
Some
it
mistake.
should have been, my lord, 1996, my lord.
Oh, it's not 1699.
No, my lord,
It should be 1996.
6, my lord.
42.
Okay, we'll
But
check it.
this case will lead that one, my lord.
Which one?
The 41 item, my lord. It is basically is the pension matter. my lord.
In item 41, let's say, I am paying for the restaurant number 11.
Have you thought about it?
Yeah, my
Yes.
lord, what happened? Petitioner is the first legally married Hindu wife. my lord. She applied for a pension, my lord, but the respondent authority insisting to give a kin certificate showing second wife. To that effect, my lord, they have filed their affidavit by the department, asking us, my lord, and managed to obtain the kin certificate, my lord, though it is a kind of communication, my lord, which I have annexed, for which I have challenged that one by 1996 of 2023, my lord.
You have also obtained a next of kin certificate.
It is not a kin of certificate, it is a mere communication, my lord.
No, that, what is it? Then page 31, annex of 4. You are appearing for Bimala Malu. You are having this next of kin certificate.
Yes, I got it.
Then
Then, my lord, she managed to obtain another communication, my lord.
Yes, it is there, my lord. Page 36. It is a communication, but department is insisting to get that certificate. Annexure 6, page 36. With reference to above, I have the honor to inform you that as per the inquiry concerned by the Mondal and Gaupura, it is found that disease Govinda so-and-so Malo was permanent resident of so-and-so village so-and-so at the time of that lab behind the following way.
Next of kin.
It's not, but the next of kin certificate address is shown so-and-so, ward number so-and-so, revenue village so-and-so, and certificate also issued on the report of the Morigao revenue village. The name of Gita Malo, second wife, and her son Gita Malo was excluded in the said certificate. That certificate, my lord, we have changed by filing a separate writ petition.
This one. This
Yes,
is not a
ma'am.
certificate, this is a report.
This is a report.
Clarification is given.
It's a, this regarding information, my lord, we have challenged by filing a subsequent writ petition. But now, my lord, the affidavit has been filed by the respondent, my lord, that your lordship will see. It has been filed by respondent number 4, man. Yeah, my lord, they said, my lord, the second wife, lordship, kindly see page 49. If your lordship go chronologically, one report has been given, my lord. That is not. Next page, my lord, 50. With reference to subject cited above, I have the honor to forward with the original application of Bimala Malo, so-and-so assistant teacher, so-and-so school regarding the pension bill. It is noted that due to non-submitted submission of the kin certificate, we are unable to process the pension proposal after the receiving the next kin certificate from the competent authority. Other records from the legal guardian pension proposal will be submitted. Now, lordship will see page 51, what he is insisting, my lord.
Page
51, my lord. That is annexure 3 of the affidavit of opposition filed by respondent number 4. There, my lord, with reference to subject cited as per letter received from BEO Lahori Ghat so-and-so, it is mentioned that you have not submitted next kin certificate along with second wife. My lord, second wife is not entitled also. Wife and children of the late so-and-so expired 80 of so-and-so Lahori Ghat. As a result of BEO Lahori Ghat is unable to submit pension proposal to the undersigned. Therefore, you are requested to submit kin certificate along with second wife. He is insisting, my lord, to submit a kin certificate, though it is a illegal marriage. As per Hindu law, it's a very.
You are referring for whom?
My lord, elementary education department.
Elementary education department. Who is referring for the government? Mr. Bokwe, from this side. Page number 31.
Yes, your lordship.
Who have issued it? Who issued this?
Deputy Commissioner. Office of the Deputy Commissioner. Morigao District.
You have the petition with you, Mr. Bokwe? Page
Yes.
number 31, you see in the top.
Yes, your lordship.
At the top.
But government of Assam, office of the deputy commissioner.
What is required is only this. On the left, you have the certificate number. The top, just see at the top.
Yes, Your Lordship.
On the right is the application number.
Yes, Your Lordship.
Right?
Yes.
Just verify and tell us. On this was in 2022, it was all online.
Yes, sir.
So after this, there will be report of the circle officer. See the report. After the heading next of kin certificate.
Page 30.
No, page 31 only.
Page 31.
Page 31, it is written in both Assamese and in English.
On the basis of the report of the circle.
While issuing that, see that report. It may not be attributed to the petitioner. This particular certificate was issued on 4th of February 2022.
Yes, sir.
Now, page 36.
Same circular.
This is a letter of 3rd of September,
Yes, Your Lordship.
much after this.
Certificate.
Is there any objection raised by the respondent number 7 in issuing this certificate? Respondent number 11, unless this is challenged before the appropriate authority, not before the High Court. This will remain. What's the issue?
And how come, my lord? The
Mr. Bokolial.
My lord, one more thing, my lord, from the page 51, I'm saying, my lord. Lordship, how come he's asking, my lord, to bring second wife as a legal here?
Maybe that Mr. Bora will know better.
My lord, how come, my lord? Being a government official, my lord, he knows about
After
the
issuance,
religion.
may submit.
After they know the religion, they
Yeah.
know everything, my
Yes,
lord.
yes.
Where the second wife has no status,
Yes.
as per Hindu law, my lord.
I am not the mother, the second wife of the deceased husband. She is not entitled, but my grievance is that the second wife has a
file
mentally
an
retarded
affidavit,
child.
Mr.
So my affidavit is also getting ready, Lordship. I will file, Lordship. Now this
You
development.
file it, then you will hear.
Yes, yes. After issuance of notice, we came to know that there is a certificate issued in the month of February 2020.
Mr. Bokolial, on the next that we need the report.
Yes, sir.
To get the
Let them place
scan
original
copy
report.
of the application,
Yes.
because it is in website. Get the scan copy of the application, scan copy of the report. And we have the order before us, right?
As well as also annexus 6 also. Because
NSX is one of the,
because here also report they make a field inquiry. After also as per the field inquiry of the concerned Latmandal. So before issuance of this notice,
Second wife has no status.
Latmandal is required. If this same Latmandal in the month of February he submitted the report, and after submit 7 months also he submitted a different report. So there may be some connivance, Lordship. So to find out the authenticity, which report is Lordship correct. So this.
we are not police to find out.
My lord,
which
he
is
is
correct,
no
which not.
locus, my lord. He is admitting that he is the second wife.
No, I am not
And what is
concerned
the
about my
status of
child.
second wife?
The rule says the illegitimate child who is mentally retarded, he is entitled for pension. That is why I am before
We'll
you.
look into that later on.
Yes. This rule
That
is
has been decided by the
Mr.
hour.
Bokolial, get this report. Page 31.
And be clubbed together, my lord, both the cases.
And Mr. Deka, file your affidavit.
A short date be given, my lord, is a pension, my lord. I'm not getting widow, my lord.
List on 22nd. Along with
1996 of 23.
WPC number 1966.
No, my lord. 1996.
1996.
Last
yes.
Of 23.
2023. The response number 7. 7 or 11?
I am Lordship 11, Lordship.
He is the second wife, lord.
I'll file it. Affidavit in the matter. Order on the said date. The Deputy Commissioner Morigaon. Not a party.
Is a party.
Deputy Commissioner, where is the party?
Director, accountant, commissioner, district.
Not a
party. Circle officer is a party.
What circle officer will do? This certificate has not been given to you by the circle officer.
Well, by hand I'll insert.
No, you cannot do by hand. You have to file your appropriate application.
No, sir. We'll do, my lord, during this thing.
Nowadays, that thing has gone.
Yes, my lord, I know.
The
In other case, deputy commissioner is there, my lord. 1996.
Mr. Oakville Government Advocate Assam shall place the relevant records pertaining to the next of kin certificate issued by the Office of the Deputy Commissioner Morigaon. With certificate number 040 22 022 dash 001 dash 0428 222 on the basis of the application number certificate location dated period 0402 2022 on the basis of the application number SSDG /ED /NOK /4295830. Mr. Mukulal, otherwise also you are appearing for free, I think so.
Yes, sir. Worship, may my name be recorded as B. Deuri.
Oh, sorry. B. Deuri. One P. Bora. How many dear? 1, 3, 1, 4. Then 7. 1, 4, 7.
7
Not in here. It is district.
1476.
District Elementary Education Officer is. I think you are wrong. In this writ petition 1479. Maybe you are holding some different petition. Okay. Finance, you know, so for idea. Who is for the finance? Okay. Finance kumbata paida, so liha kumbata paida. Or idea. There is AGA some 5. You are appearing for 6 employees who will finance 2 and 10. And Mr. Rekha, Grant Council for the private decimal number 11.
Today, some cases were listed before code number 10. The cases were disposal with observation. Fix on Monday.
We'll have it on next Friday. Then you'll have the copy of the order. Okay, we'll have it on Thursday next. '28.
Then the interim order will continue.
We'll get the interim order passed. We have the concentrated practice too.
Cycle number 57.
Have the lordship. Lordship, pursuant to order dated 4/8/23, Lordship, I has been filed for implement of Finance Department, Lordship, as well as Treasury Officer. Who is with Finance, you will appear? Ask anyone to be here, no problem. The hard Mr. ZRA Mutia, council appearing for the petitioner. You will be appearing for whom? And you are for irrigation?
No, AG, it's 405.
Who is for irrigation? Likha, A, B, Devi Likha. For opposite party number 2. Number 1 Likha. 5. Who is appearing for irrigation? Just Mr. Upadhyay. For 1 or 4. And insert Likha. Mr. Bora Likha, D Bora for number 2. Finance is not here, not this matter. Okay. Be here, will be required now. The applicant as a writ petitioner refer the connected WPC number 1129/2022, which is presently pending for adjudication. Paying for premium paying amounts others or compensatory benefits amongst others, who retired as a deputy chief engineer. No, he retired as
Workshop section assistant.
Workshop section assistant in the irrigation department. Under executive engineer Karbi Anglong Division Difu. By this interlocutory application, the applicant slash petitioner of WPC number 199 needs for implement of the Commissioner Secretary Government of Assam Finance Department, as well as the Treasury Officer Karbi Anglong Difu, party respondent numbers 7 and 8. Inside WPC number 112920. After hearing the counsel for the applicant and the opposite parties, this court is of the view that the Commissioner Secretary Government of Assam Finance Department dispute Finance Department, as well as the Treasury Officer Karbi Anglong Difu are necessary parties for proper adjudication of say WPC number 1129/2024. The prayer between the distance alone. Next, WPC in view of the order passed today in the connected WPC number in view of ISC number 2463/2023, such and such being treated as party respondent number 7 and 8 in the present petition. So B Gogo Standing Council Finance has entered appearance on behalf of newly implemented respondent number 7. This is a corrected instruction perspective. Automatic registry correct for purpose of B Gogo. Petitioners are requested issue notice to the newly implemented respondent number 7 and 8, returnable by 28th of September. Petitioners also requested extra copies of such and such to Mr. Gogoi by tomorrow obtaining necessary acknowledgement. The name of SC file may be registry shall reflect the name of registry, consent section of the registry shall reflect the name of
My lord.
Standing Council Finance for the newly implemented responding number 7. Yes, Mr. Speaker.
Maybe, but item 48 was hearing first item on the 48. 48, my lord. My lord, Mr. Asri Thakur, he has informed me, my lord, because that the petitioner has expired, my lord. So it is an infectious matter, but in no respect. So his order may be passed in respect, my lord.
Mr. Gogoi be here for a few minutes. Another finance matter is.
Asri Thakur, my lord, he has informed me today. See. And almost 80% relief has been given to the petitioner. But he has expired, unfortunately. All practical plasma is infectious. And nobody is coming forward for substitution even.
Mr. Sharma, whether the person has received his pension or not. When did he expire? Any idea? (2012, 13), it's now 11 years. He was retired long back. 2020, he has, when did he expire? Any idea? When did he expire?
The daytime would be given, my lord. He just informed that he expired a few years back. If you notice, I can ascertain it.
But Mr. J.K. Sharma, learned counsel appearing for the petitioner. Any standing counsel for information and public relations? Mr. D. Bora, Government Advocate Assam.
Because over he must have retired also in the meantime, no?
And
It is
Mr.
a 9 years
Standing
senior.
Counsel Finance for the respondent number 6. Also heard Mr. B. Chakraborty, Standing Counsel, AGA Assam for the respondent number 6. I'll go to 5 over to 6. R. D. Bora for 1, 2, 3, 4. Mr. Sharma, on instruction submitted that the petitioner has already expired and none from his family has come up forward to file any such substitution petition. In view of the above, petition stands corrected. In talks of
Lordship, there was an interim order.
That's true. What to do? Recovery was stayed. Now you cannot recover it from the deceased person. Right? Not even from whatever. That's why we inquired whether a pension amount should be given or not. Right? But automatically, that's though you are silent, once the petition is closed, then that order revives. But you're not able to recover. That's all.
May I please your lordship? My lord, this is the review petition. And we have sought review of the order that may be seen, my lord, page 17. Item 1, 17. Your Lordship would say, I am coming to certain points, my lord.
At this moment, what will do, Mr. Chief? Just take notice, whatever you have to objection, if you sir, then we'll do that. Straight away. Right?
Yes.
It has come for the first time.
No, probably these matters have come.
Earlier it was
No, this met. अपना तो first time है अपना तो first time है हाँ
আহিছিল কিন্তু এপ্রোপ্রিয়েট করে দেখা নাছিল
So you'll submit or you'll file objection? Round of reviews.
Yes.
Up to you.
First of all, my lord, probably the cases were listed. In these cases, my lord, the prime issue was whether delay was the issue, my lord. Delay in filing the review.
Okay.
That was the prime issue, probably, my lord. The delay in filing the review. Whether delay can be condoned without filing delay, my lord, condonation petition.
I think Justice Mehdi and myself passed an order.
Yes, probably, indeed.
Mr. Please take your seat. Please take your seat. Just finding out something.
तो मैं सेपरेट पिटीशन फाइल करी सेपरेट कंडोरिंग के लिए नॉर्मली एपीएसडी में कंडोनेशन কথা না है কিন্তু বেসিক্যালি হলে এক্সক্লুশন ইয়া বাদ আমি কিছু সেপারেটলি একটু কন্ডিশন ডিভিশন ফাইল করেছি
Hello. এই তাতে সেইটো কেছত ফাইল করতে না মেমোরেন্ডাম আছে মেমোরেন্ডাম কোন ফটোকপি করে ফেলে এইটা মেটার যে আছে moral justice material judgment was needed. Yes, please come. Show us.
May I please, motion? My lord, the
Show us
delay
where is the
matter,
illegality, please come to the order.
yes, that is the main thing. Delay matter may not be serious
Let us
because there are so many judgments of our High Court
No,
also.
no, we'll come to that later, but show us what is the.
Yes. Now Lordship may kindly see the order we have sought to review, that is page 17. Now, Lordship would see para 6, page 19. Mr. Swainso submitted that subsequent thereto, the petitioner filed an application under Order 9, Rule 13 CPC, read with Section Swainso, urges the amendment rules, Order 2013, for setting aside expiry order dated Swainso, as this court had observed in the judgment on order dated Swainso that petitioner had not availed the remedy of setting aside an expiry order by filing an application before the learned tribunal. Therefore, the learned tribunal was not justified in passing the order dated Swainso, rejecting the said application on the ground of dismissal of the petition filed by the petitioner, filed order dated Swainso. He submits, it is further submitted that there was a confusion in regard to the identity of the petitioner with that of another person with the same name as well as the same name their husbands, and therefore the learned tribunal ought to have considered this aspect. Here, my lord, the name Joyful Nessa, wife of Shamsulek, in the same village there is another Joyful Nessa, and her husband is also named Shamsulek. That is there. So this aspect should have been scrutinized by the learned tribunal. So whether and that joyfulness against that joyfulness name, there was the word D, but against my name there was no D. But even then, police served notice on me. I appeared, I said, but that was not considered. It's a very important factor. And this Honorable High Court also did not ask the tribunal that inquired the matter, whether this joyfulness is the original proceeding or the joyfulness against whose name there is D, she is the original proceeding. That was not considered right. That I have annexed certain documents in writ petition.
First of all, only when if you will allow this review, we'll go to that extent. Yes.
Annexers, Lordship, your Lordship wants to see annexers. Kindly see page.
Okay, what is the submission with regard to the delay?
Delay point, my lord, I have explained in the that may be seen page 9. para Roman 2. As 9, Roman 2, grounds that the Honorable Guwahati High Court in its impugned order dated 37/2018 upheld that the order dated 11/2/2016 passed in WC now and primary reasons upon which the Honorable High Court relied upon while passing the said order were that there has been an inordinate delay in approaching the Honorable High Court as the impugned order passed by the tribunal was on 4/7/2009 and the writ petition has been filed more than 6 years after passing the expedited order. Therefore, without going into the merits of the case, the writ petition was dismissed on grounds of delay. But the aforesaid observation is incorrect and erroneous as the Honorable Guwahati High Court in a slew of cases have set aside expedited orders on subsequent developments or due to bona fide reasons such as order dated 9/9/2021 passed in WBC numbers 6544 W2019 had set aside the impugned expedited order dated 26/4/2011. So passed in case number FT so and so and by order dated 20/2020 passed in WBC number so and so had set aside the impugned expedited order that is 6/4/2010. Passed by Foreigners Tribunal Jorhat in case number so and so. In both the above mentioned cases, the writ petitions were filed about 8-10 years after the impugned order. Opinions were passed by the learned tribunals. So we have also annexed the order. That means 8 and 9 years, 8 to 10 years later, review petition was filed, writ petition was filed, and that was allowed by the Honorable High Court. Annexed, we have annexed the order here. And here is the case, my lord. In our case, the order of the learned tribunal was passed. That order of tribunal was passed on 14/7/2009. Honorable High Court passed order on 30/7/2018. 30/7/2018. And we have filed the review petition in 2022. They are hardly 4 years. And in those cases, where the delay point was considered that was not the ground, and delay cannot extinguish the right. And for delay, my lord, there are so many judgments of our High Court that delay, my lord, delay, on the point of delay, the case should not go. And just recently, my lord, I think, my Lord Justice, the other day, it is order dated. In review petition number 116, my lord. 116/2020, Rukia Khatun's case. Just, I think, nearly 10 days back. On the ground, my learned friend was also there. And I think, my Lord Justice, was also there. So it was the observation of the division bench in Rukia Khatun's case, review petition number 116/2021, that the review petitioner has given some explanation of delay. So for the separate petition is not necessary. So delay point was decided accordingly.
Now here you have explained your para 9.1.
Yes, ma'am. So, my lord, there are so many citations I have not.
Now, your ground of review is for what?
Yes, ma'am. That lordship I am coming. That may be in page 9 on page 9. These are the grounds I have mentioned. The real ground will be evident from the order, my lord. Kindly see page 19 bottom. Page 19 bottom. Here you see. In the judgment order dated 11/2/2016, by which the writ petition was dismissed, this court had stated as follows. Learned counsel for the petitioner submits that petitioner was not declared as a D voter. At any point of time, even till today, she has not been declared as D voter. Therefore, declaration of the tribunal that petitioner is a foreigner is untenable. On the other hand, he submits that there is another D voter by the same name as that of petitioner. Perhaps because of such confusion, tribunal had arrived at the aforesaid conclusion, which is clearly erroneous on fact, on a query by the court as to why petitioner has approached this court after more than 6 years. Learned counsel for the petitioner submitted that firstly, she is an illiterate lady unable to comprehend the serious consequences of her default, and secondly, she had no knowledge about the impugned order till 30/12/2015. Only when police started charging her for her, she came to know about the impugned order. Therefore, court may intervene in the matter and grant some relief to the petitioner. Then Lordship may see there is objection from the other side. Now court is saying this proceedings before foreigners tribunal. Lordship has seen proceedings before the foreigners tribunal summary in nature. It is not a full-fledged civil proceeding like a civil suit. The Honorable Supreme Court in the case of Sarananda Sonowal versus Union of India 2005 says has held that the procedure adopted under the Foreigners Act 1946 and the Foreigners Tribunal of 1964 is just, fair, and reasonable, and does not offend any constitutional provision. So, my lord, we are also expressing our unanimity with this order. But whether that was followed or not, that is the question. Although the court is required to see at this stage is whether a fair opportunity was provided to the noticee. In this case, the petitioner, when the petitioner had received the notice of the tribunal and had engaged counsel to defend herself, subsequent repeated default, that too without any sufficient cause, cannot be accepted. Moreover, the impugned order was passed as far back on 4/7/2009. Writ petition has been more than 6 years thereafter. Explanation given by the petitioner that she is an illiterate lady which prevented her from approaching the court earlier would be of no assistance to her, as inasmuch as she had engaged a counsel to defend herself in the proceeding before the tribunal. Therefore, second explanation given that she came to know about the order of the tribunal only on 30/12/2015 also cannot be accepted because she was aware of the proceeding before the tribunal. So, my lord, here the Honorable Court has taken a very rigid view. My lord, first thing is not, we are not saying it is a completely civil procedure has to be followed. But thing is, fair opportunity should be given. Here is a case, my lord, where in the same village there is two joyful lessons. And fortunately or unfortunately or incidentally, their husband's name is also same. But my point is this, in against the name of another joyful lesson, the letter D was inserted. But against my name, there was no D. So this is a very crucial aspect of the case. Confusion is natural in such type of cases. And my confusion was based on solid ground. That's because I have no letter D in my name, against my name. So my case, I may not be the proceeding in the present case. So she was under that impression. Whether her impression was right or wrong, that is of course a different thing. Every person does not think alike. Persons differ from case to case, mind to mind. So that was her feeling, my lord. Now, so insofar merit of the case is concerned, we are not inclined to enter into that aspect of matter, since on due consideration of the matter placed before the tribunal, tribunal had arrived at a conclusion which certainly is a possible conclusion based on matters on record. Lordship. Now, the Honorable High Court not inclined to enter into the aspect of matter. So only that expeditive order was passed because she was absent. So Honorable High Court did not want to hear the case on merit. Had it been decided on merit, because well, here is the question of life and death. A person, if he is thrown out from the citizenship right, so the Honorable High Court has taken a very rigid view, which is, in our humble opinion, not acceptable. Delay point should be considered liberally. So there are so many judgments. The issue relating to recall of expeditive order has already been gone into by full bench of this court. It's a reported so and so. On special or exceptional circumstances, ex parte orders can be recalled and not in the routine manner. Yes, my lord, that is it. It is not a routine manner. Every day, my lord. Every day, court number 6, almost we are conducting cases. All the ex parte orders have been set aside, has been set remanded back to the tribunal, but some penalty has been imposed. 2,000 or 5,000 or 7,000. The other day, my lord, day before yesterday, I have paid, I means my client paid rupees 7,500. In that is the case was Razak, Abdul Razak, one case. So, my lord, that is the thing. Honorable High Court in each and every case, ex parte orders have been set aside, subject to payment of some amount, 7,000, 5,000, or as the case may be, and that should be deposited before the legal authority, it's the district legal authority, and thereafter they would show that receipt, and then the tribunal would enter in the case. So, my lord, I am a lady, and we are rustic lady, my lord. They are not so much aware about their case, and the honorable judges are aware about the backwardness of these persons. So, our humble opinion is this, my lords, that this should not be taken so seriously. She should be given a chance, because, my lord, she has many documents, which I will show for your kind satisfaction. Now, this is a not a test, my lord, this is the view of the Honorable High Court, and our humble opinion that should be reviewed. And those reasons I will submit. I have also brought few citations. A delay of 6 years, and in that case, which I have read just now, page 9, Roman 2, there are 8 to 10 years delay, and here in this case, nearly 6 years delay. So, my lords are aware that if the coordinate bench does not agree with the other coordinate bench, then matters should be referred to the larger bench. So I think that may not be necessary in this case. So that is the case, my lord. Now, the another thing, yes, it is observation that it should not be a routine manner. I also admit that it is not routine manner. We have some foundation. Of course, whether that foundation is legally acceptable or not, that is up to your lordships. But that was her thinking, that was her bona fide belief. So now let me go through some citations. These are the things which should be reviewed. Another thing, my lord, for a moment, let me complete first. Then you will say. Now, let me show your lordship kindly. Kindly see, my lord, page.
Take your seat.
Kindly see, my lord, page 40. Page 40. First thing, my lord, my father.
No, that we will not see. At this moment, we are not on that. First, the grounds of review we have to clarify first. So, what are the grounds that you are already writing? Anything else?
Yes. So, this is short order, my lord. So, grounds are like that. Ex parte order was not set aside, and order of the learned tribunal, which was passed ex parte, that hold the field, and as a result, the petitioner went up to Honorable Supreme Court. She went up to Honorable Supreme Court. Now, Supreme Court's order, we have concealed nothing, man. Supreme Court's order, lordship may kindly see page 82. 82? Yes. Upon hearing the counsel, the court made the following order: heard learned counsel for the petitioner and perused the relevant material. We find no merit in the special leave petition. The same is accordingly dismissed. Now, lordship, a very important question may come. When the Honorable Supreme Court has dismissed the writ petition, then how High Court would entertain a review petition? That is a very important question. For that, my lord, we have brought citation. We have brought the Honorable Supreme Court's decision that, my lord, let me see. Let me satisfy your lordship. This is 2009. sorry, 2019. 2019, 4 SCC 376, para 28. Para 20, I have given the citation. Not para 28. किताब तो बाहर करने को किताब लग होता है citation तो बोलो citation तो किताब बाहर दिया आरोटास वो दो टकी
One will do. Get it from here.
Kindly see, my lord. 2019, 4 SCC 376, para 28. Last page. Last page, kindly see, my lord. Last page, para 28. In the instant case, since a special leave petition was dismissed in Limine without giving any reasons, the review petition filed by the appellant in the High Court would be maintainable and should have been decided on merits. Order dated 12/11/2008 passed by the High Court is accordingly set aside and matter is remanded back to the High Court for deciding the review petition on merits. The civil appeal is disposed of accordingly. So, Lordship would say here, the Honorable Supreme Court dismissed my petition. But the Honorable Supreme Court also, Lordship, if your Lordships kindly go through the order, heard both sides, dismissed. There is no speaking order. What are the materials produced before the Honorable Supreme Court? That was not there. Only summarily it was dismissed. Now, the same Supreme Court says, if no proper reasons or speaking reasons are not there, then review would lie. High Court earlier rejected the review petition. Supreme Court says go to High Court and High Court should consider the same on merit. Now, my lord, side by side one thing. When a person claims to be a citizen of India, every authority should be very much active that whether this person is claiming to be a citizen of India, he or she should be given maximum opportunity to prove her case. Now, I have so many documents, 66, my father, 70, many other documents I have. So this is a prima facie evidence that this person is not a suspicious person or not a Bangladeshi. So she should be given a chance. That is Sarbandha Sonal 2007, the second, Sonal second, everything has been clearly stated. Lordship is aware about that. Sonal 2, here the Honorable Supreme Court has repeatedly said, fair opportunity should be given. What does it fair opportunity? Suppose she did not go even after receiving notice due to her misunderstanding. Does it mean that she would not get a chance when she has so many other documents to prove her case that she is not a foreigner? So the Honorable Supreme Court says that in that case, when the Supreme Court dismisses the SLP in Limine without passing any speaking order, then review would lie in High Court and High Court should decide the same on merit. So, my learned friend may say, as she went to Supreme Court, no, the Supreme Court has given me that right. Then, Lordship, my lord, they kindly see, case of Abdul Quddus. So, here, my lord, Abdul Quddus, 2019, I have given the relevant portion of the copy, my lord. Para 28, my lord. Para 28. Here, it was highlighted that there could be contradicting decisions, opinions of the Foreigners Tribunal even in cases of near family members, albeit contradictions can be avoided when family tree hearings are held as is now being undertaken. In the absence of joint decision, conflict is possible as the principle of res judicata would not apply to separate proceedings even if against two closely related but different persons, as each case has to be strictly decided on the facts and evidence on record. Secondly, there is a possibility that one of near relative members have migrated to India prior to midnight 20 of 24/3/77 and therefore fall in a different category. Any such conflict, however, would not compel us to take a different view in terms of the clear statutory provisions. In a given case, the person aggrieved would have liberty to invoke writ jurisdiction or, if necessary, review jurisdiction before the High Court or this court to ensure that no injustice is done. Any order passed in case of close family members subsequent to the adjudication order determining the citizenship status of a person would necessarily be a material evidence which can be duly taken note of and considered while deciding a writ petition or review petition. So, my lord, here in respect of close relatives, if any order is passed, now, my lord, we have filed some documents.
Mr. Mahmood, submit on the ground of review. Those facts will be only when we take up your
No,
petition, right?
In Kodus
So-
28 is clearly saying any order passed, close lordship kindly see, my own sister has been declared Indian. What more, my lord, that lordship kindly see pays leave provided, that may be seen, my lord. First lordship kindly see pays 83, my lord. 83.
Time is up. 4:40.
Here lordship would say page 83 on
I can stay back. My lord's convenience.
Because I took me to the head of work, it probably has it delete possible.
17th.
7th of September.
Any difficulty?
Sure, this is what I will adjust.
Normally, as you know,
Special
ma'am,
bench, since 2 benches are.
true. Ma'am is already sitting in a different DB.
No.
So that's why we are thinking of having on 7 from 10:15 onwards. Probably
Yes,
for the
that
day,
will
so
be
that
better.
will be easier for all.
Yes.
So tell us if you have any difficulty, you have to fix some other date than that. Eight, you have any difficulty?
Lordship, I will adjust.
7 possible?
7 possible.
What are you saying? If it can be carried over to 8, if we cannot complete it on 7th, so we'll have it on, for a timing, let it be on 7th.
7th Lordship, I can adjust. Let me just see the 8th. if I can.
When you can just, when you please give a date.
8th will be difficult for me. Lordship.
Okay, we'll have it on 7th.
I have a part third matter before Delhi High Court.
No problem. We'll see.
So 7th is okay.
Yes,
7th I will-
fine. We'll have it on 7th. We'll be there for a whole day. But what I will be requesting all of you who are here for review, well, just place the ground of review. That's all, not beyond that. We are not going to, unless and until we enter the backup to the read petition, we will not see the documents, only ground of review, that's all. Prepare the short notes and give it to us. List on 7th of September. Harding Park quickly.
My argument should continue.
Yes, it will be Harding Park, so we'll have it on 7th.
Yes.
বাকীবিলাক চব আহি যাব কাৰণ বাকী ক'বই নালাগে বেঞ্চখন প্ৰস্তুত
লাগে
এই লিষ্টে কন্টিনিউ